Should be.
No, I lost the page.
Yes, you did. You ruined it.
All right, I'm in possession of the bind over documentation on docket 2401740. This has been signed by both parties. I will sign that this examination has been waived on today's date, which is June 27th, 2024. And I'll only place for on the amended charges that it is a regular habitual, not a regular habitual notice. Is there anything come to the court's attention before I sign the bind over documentation, Ms. Wilson?
Not on this file.
Mr. Palmer?
Not on fire. Thank you.
Thank you. I'll sign the bind over documentation. Mr. Williams, on this file, your time in district court is done. You'll get your next date from your attorney, Mr. Palmer, okay, on this file. So that's all for the record in 2401740. And then we have the pre-trial that we can reset for it would be reset for another Monday or?
Yep. Does he need
That was the dog case.
Yes.
so like 4 weeks?
Yeah, I could get it done before.
Okay.
That'd be good.
We could do like 3 or 4 weeks.
So on a Monday, 30 days out? That Wendy didn't give you a date for, but she'll know exactly what we're talking about.
No, she did not. She gave me resets for the prelims and then a sentencing date in August.
All right.
So I had, you said Monday, so you probably do the 29th.
Okay, perfect.
I'm just gonna look here, make sure. Yes, 29th at 9, July 29th at 9 o'clock.
All right.
May I have a case number, please?
Yes, it's 2400548.
Okay, thank you.
It'll be reset for Monday, July 29th.
As long as your attorney gets a photo of the license ahead
9
of time,
a.m.
you can be by Zoom. But if not, then you should probably come and bring the license with you.
Yeah, and that's reset for 30 days. So all right, so we've reset that for Monday, July 29th at 9 o'clock. Anything else for the record for the pre-trial on 2400548?
Not for the people.
Mr. Palmer.
Not for the defense.
All right.
Thank you.
So we'll see you on Monday, July 29th. That's been reset. Okay, thank you.
Mr. Paul, have your client wait here. I'll give him a notice.
Yep. Sounds good.
Robinson's still there.
She must be still in the area, Judge, but she's not sitting here.
She might be talking with her.
With Mr.
client.
Lavoy.
I don't think Mr. Lavoy. I think Mr. Jones, she's probably talking to.
Okay. She also has Mr. Lavoy in lockup.
Yes.
See, it's 29.
Is that?
My understanding,
Yeah. At 9
my
o'clock.
understanding he's gonna be asking to represent himself today, so.
All right, man. I'll be in touch.
Do you have witnesses here on that?
Yep. Take care. Judge, I guess while we're waiting, can I verify, do we have interpreters lined up for Felipe Gonzalez tomorrow
And Jose.
and Jose Gonzalez?
That's a great question.
That case is going to be an we were talking about.
Yes, we were,
It's going to be an
yes.
absolute mess.
We're gonna need interpreter for each defendant and then an interpreter for one of my victims. So we're looking at possibly 3 interpreters.
When is that set?
So it's the
The Friday.
PCC is tomorrow, the prelims next Thursday.
All right,
It's not, I don't think it's gonna be next Thursday because of
right,
Next
stuff
Friday.
going on.
Next Friday.
Next
Prelims.
Oh, that's
'Cause we're
right.
off
Yeah,
on
because this
Thursday
is
because of
prelims.
right.
Prelims.
So
Yep.
you're
Okay.
doing the PCC tomorrow.
Yes, yep.
Yeah.
Let me check.
Okay.
Let me
Yep.
check because Wendy's going to be here in the next hour.
Okay.
If you've requested them, but I didn't know if we have that many.
No.
Well,
There's 3. There's one for the defendant, one for the witness.
Yeah, well, so there's co-defendants, my client and my
Yes.
client's brother, neither of whom speak English.
Okay.
So they would both, I think, then need their own.
Yes,
I agree.
Kareem Johnson has the co-defendant.
yes.
And then at least, I think only one
I
of
think
the
only
victims,
one,
right?
and then we would provide an interpreter for
Okay.
that person.
I think we have, I think we've got,
I
the
would
court
assume
provides two.
so, because at arraignment, I'm pretty sure whoever arraigned them would have picked up on that they need an interpreter.
I hope so. I hope so.
The other thing I would say is that it is, that without going into the details, that case is a mess.
Yes, yes,
And I don't think Jose is in custody, right?
Neither of them are.
Yeah, my guy's not in custody, because my guy came to my office and met with me for almost 3 hours
All right.
yesterday with
Yeah.
an interpreter, and if we need to, I'm entirely open to the idea of adjourning the prelim a little bit so that we can try to figure out some things, because there's a lot of.
Right.
Yeah.
There might be more discovery, more
More
investigation.
discovery, possibly more co-defendant.
Okay.
Yeah, there's a whole bunch of people that were not just never
Yes.
figured out that probably should be involved.
All right.
A lot of empty chairs in that case.
But to your first question, I think we have interpreters
Okay,
tomorrow,
yeah,
but let me double check on that.
Fair enough.
Yeah, let me make sure on both of those. And then you're providing the interpreter.
yeah, our victim witness unit will provide an interpreter for the witness that needs it.
Yeah, so we would provide it for each co-defendant.
Yeah.
And that should have happened.
Sure, yes.
Yeah, I don't know that it did
Turning
happen.
into kind of a Mirage situation where like 4 different people have interpreters.
Yeah, it's gonna be a mess.
Were they both arraigned by language line?
I don't know, I haven't looked. They had to have had something because they speak no
Right,
English.
I bet you they were arraigned by
Yeah.
language line.
It's because it's one of those, it's also one of those things where like police are taking statements using Google Translate and
And
it's just,
some language line and,
it's a mess.
I understand.
yep, yep.
My guys ready to go.
Yeah, Peterson's here, I haven't seen Hall yet,
Okay,
so let me go look.
all right. While you do that, I'm gonna run down and just tell Buchanan that I'm here because I
Okay.
think they have one at 9:30.
Okay.
And she screams at me sometimes.
My witness is here on newbie, my officer is in traffic court with Magistrate Bilmore right now.
All right,
So I mean, we're just kind of waiting on
you
that.
just let me
one.
know when we're ready.
Yeah.
And did we start newbie?
Yes, yep, yeah, we're finishing up direct with the complaining witness, and then Ms. Wanji is crossing
Right.
the complaining witness and my officer.
All right. I should have known someplace different.
That was great.
Right where she said.
think we can do Dominic Thompson.
All right. Mr. Lavoy, so he's currently retained, Ms. Robinson, but he
Yes,
wants to go
she's
forward on his
in-
own.
That was what he told her yesterday.
All right. I may appoint standby counsel for him,
That would be my
just in
request.
case.
Yep.
just in case he has any questions concerning the system, etc.
No, you go, yeah.
Judge, for your awareness, Dominic Thompson seems to be incarcerated in Eaton County today, so.
Oh, so he is.
Yes, we can put that on the record. There
That's-
is,
Yeah, okay,
yes.
that explains that one.
Yes.
That's what I meant to do. I knew I forgot to do something. I was in the middle of syncing it and then I never.
Letitia.
Okay.
Yeah, mhm, yeah.
All right, so that's Mr. Thompson.
It's not. I'm just looking for something.
All right, so we're on the record in docket 24-00975. That is people of the state of Michigan versus Dominic Thompson. Will the parties please introduce themselves for the record? I have two files today. I have a preliminary examination and then it must be a bond violation.
It is. I was curious about the way it was coded.
Yeah, it
I
was
believe
coded as a
it's-
rain pretrial and that's,
I believe it's a bond violation.
Okay.
Yeah.
all right. Appearances for the record, Ms. Wilson,
Abigail Wilson for the people.
Ms. Schroeder.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Thompson, who, as the court is aware, is not here, and we can get into that in a moment.
All right, Ms. Wilson, this is the time set for preliminary examination. It's my understanding Mr. Thompson is not here because he's changed facilities.
Yes.
You may proceed with the record.
Thank you, Your Honor. The last we had known, he was in Clinton County. Yesterday, it appears that he was moved to Eaton County. A writ had been sent to Clinton County because that's where we thought he was. So obviously he wasn't brought over here because he's not in Clinton County. We're honestly not sure where he'll be in the next one. I think Ms. Schroeder and I have a possible plan on what to do. So I think we're just gonna need to reset this and possibly, I guess, send a writ to Clinton because I think that's where his bond is currently.
So it'll be a writ to Clinton
Yes.
Again,
Yeah.
again.
and I can give some more reason for
All
that in
right.
a moment, Your Honor.
All right, Ms. Schroeder.
Thank you, Your Honor. Yes, as the prosecutor, Ms. Wilson has indicated, it came to my attention earlier this week from Attorney Pollock, Daniel Pollock, who has been brought in to handle Mr. Thompson's matters in Eaton County moving forward. That he, reread this here, that he had been brought from, at some point in the past, since the last time we were here, he was brought from the Clinton County jail, which is where he was at the last court date we had supposed to be here, which is why we sent the writs there.
Right.
Sometime since that court date and today, he was then moved to Eaton County to handle the matter. He's on, he has new case. I'm not sure which. He said, it indicates, you and I can talk about that. Anyways, regardless, he ended up back in Eaton County and to resolve a matter he had there. For whatever reason, he has remained in Eaton County, but he has no bond in Eaton County. But the belief is he will be sent back to Clinton County, and I don't think he has a bond in Clinton either. So at this time, I would imagine we need to send a writ to Clinton County again.
That's where we'll try again.
Are we
Yeah.
able to send a writ to both?
That's what I was wondering. That's why I
Yeah.
paused. That's why I
Yeah.
paused.
Is that a thing we can do?
I don't know.
If we can, I think that's
I think
a
we
good
should try,
idea.
because
Yeah.
If we can, we should try. If
Yes.
not, we'll
If
just
not,
go to
we'll do
Clinton County.
Yeah. Mhm.
Yes, because as I was rereading the email from Mr. Pollock, if he has no bond in Eaton County, I don't know exactly how he's gonna get over to Clinton.
Yeah, because I
County.
think his bond in Clinton is like 25,000 cash surety.
Okay.
So I
So-
don't know if they would take him from,
Yeah, so yeah, I have no idea.
I'm not sure it
No
works.
idea.
His attorney in Eaton seems to think he will be going back to Clinton County, but I have questions about that.
I mean, he'll at least be going back for a court date at some point.
Yes,
Yeah.
his next court date in Clinton County is July 1st, so this
Okay.
Monday. That's why I was hopeful he might be here today, is that,
So what, how long are we looking to reset the prelim for?
that's, brass tacks, yes. Your Honor.
3 weeks.
Yeah, at that point.
Outside of 3,
Yeah,
You get sentenced.
and this is a good cause adjournment.
yeah.
So he hasn't waived anything. He hasn't waived any rights. We're just having trouble getting him there.
Your Honor, he has a court date on Monday in Clinton County, in Eaton County. His next court date is August 23rd, 24th. I will, after the first on Monday, I will try to get a hold of his attorney over there in Eaton and try to figure out, could be bounced back to Eaton County?
Right.
Because I could see that
July
happening.
19th enough time,
I think that should be
All
okay.
right.
July 19th at 9 o'clock.
And I will let the court know if I have any updates after Monday.
All right, so July 19th, reset for prelim. This is still a good cause adjournment because we're just trying to get Mr. Thompson here. I will also reset the bond violation hearing for that date, which is July 19th at 9 a.m. And what I put in a note, and then I'll discuss this with the court staff. The plan is to send a writ to both places. If we can't do that, we'll send it to Clinton County. All right. All right. Anything else for the record in docket 24-00975, Ms. Wilson?
Not for the people.
Ms. Schroeder.
Now for the defense, thank you for the court's
All right.
patience.
Thank you.
I just don't know if they. How is he going to-
He's gonna, and it's also like, I don't know if it's like a first come, first served, because I think he was in Clinton and then remanded at Eaton. So I don't know if Clinton has first dibs.
You got on bond. from
Right.
Eaton, picked up
When
bond
on
case,
Clinton,
and
and then
picked up bond
Clinton,
case, and then
yeah,
picked up Clinton's case, and then
right,
he got remanded to Eaton.
yeah.
From,
Which is why I think sending them to both is a good
Yeah.
idea, because we have no
Yeah,
idea where it's gonna be.
we're not
Yeah.
sure. I just don't know if we can.
I don't either.
I don't either. I've never had to make that decision.
Yeah, So we're on the record in docket 24013668. All right.
Just give me 1 second to go get him.
Oh, you're
Sorry,
good.
get
Okay,
set
no
up.
worries, no worries.
Palmer's got to scooch out of the way here.
Yes,
Yeah.
I'm sorry.
I think you're being called.
Yes. Absolutely.
Ms. Robbins, you have Lavoy that may or may not be, but you may be standby counsel in Lavoy.
Yeah.
And then you have Mr. Brute.
I do.
Okay. All right, Mr. Jones, you can come up here, have a seat next to your lawyer. So we're on the record in docket 24013668. That's people of the state of Michigan versus Tyrese Jones. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Robinson.
Aaron Robbins, Assistant Public Defender for Mr. Jones.
And sir, you are Tyrese Jones, is that correct? Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. My witnesses are here today. We are ready to proceed.
All right. Are there any pre-trial matters or preliminary matters to come to the court's attention before we get started, Ms. Wilson?
Thank you, Your Honor. The general sequestration issue, both my witnesses are officers. Neither of them are present in the courtroom.
All right. Ms. Robinson, any preliminary matters before we get started today? Do you see any witnesses that need for me to invoke a sequestration order? I will wait to hear from the lawyers if I should invoke, and then I will act appropriately. Ms. Robinson, any witnesses that you see in the courtroom that should not be in the courtroom?
I don't think so, no.
All right. All right. With that understanding, Ms. Wilson, you may call your first witness.
Thank you, Your Honor. The people call Officer Jamil Jones.
No, this is. You're gonna have to wait till the fire truck is done.
I'm actually going to start with Officer Donovan Moore, Your Honor.
Okay. Officer Moore, you can come up here, stand right in front of myself and indicate your first name and last name and spell them both for the court report.
Donovan Moore, DONOVAN MOORE.
Please raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, have a seat. The microphone, as you know, is for amplification purpose or for recording for the court recorder. So please project as best you can and let me know if that fan is bothering you.
Yes.
Ms. Wilson, you may proceed.
Thank you, Your Honor. Officer Moore, where do you work?
As a Lansing police officer,
And what is your job title?
I'm a road patrol officer.
What are your general duties?
Responding to calls for service when citizens make complaints or calls to police.
And were you working as a Lansing police officer on May 6, 2024?
Yes.
What were you wearing?
My uniform right here says police on the back, has my badge, has my radio. So that's my last name at first.
Thank you. And is that a department issued uniform?
Yes, this is our full uniform.
Okay. And on that May 6th date, were you dispatched to 4833 Dunkel Road?
Yes, there.
Is that in Lansing,
Yes, it is.
Ingham County,
Yes,
Michigan?
yes.
And what were you dispatched there for?
It was multiple callers of a shots fired complaint. There was someone in a vehicle doing donuts and actively shooting outside of the car.
And going into this call, what was your priority?
My priority was just making sure people were safe. It's very known that Lansing has a lot of gun crimes and everything. A lot of people shoot out of vehicles all the time. So I was concerned about, especially right there at Trappers Schools, you have people that go to college right there, just a different age range and everything. So make sure citizens are safe.
And so when you get there, can you describe the scene a little bit?
Yes, there was a lot of people kind of running around. I was a little bit later in there. So I was advised by Officer Stover that the suspect that was possibly driving that vehicle ran into one of the addresses right at the end at Trappers Cove. And so I get there and I go to the other side of that address and I pulled my handgun out, was at the low ready, just making sure that person didn't just run out of the back, make sure I get it really nice contained.
So if I'm hearing correctly, your concern there was that there was somebody in one of those apartments that might be armed.
Yes.
Okay. Now at some point during this, did you assist in making an arrest?
Yes, I did.
Do you recall the person's name that was arrested?
It's Tyrese Jones.
And during your interaction with him, did you get a good look at him?
Yes, I did.
Do you see him here today?
Yes, I did.
Can you point him out and describe something he's wearing?
He's to my left wearing a black hoodie with a gold chain and a white t-shirt underneath.
All right. Your Honor, for the record, I'd like to reflect identification.
Any objection to the witness identifying the defendant for purposes of prelim?
No
Mr.
objection.
Robinson? Without objection, the witness has identified the defendant.
Thank you, Your Honor. And are you the officer that initially arrested him?
No, I was not.
Okay, and so at what point did you make contact with him?
So at that point, we were just putting people in handcuffs that were coming from the department at that apartment, excuse me. I made contact with them when Officer Jones told me that Tyrese
Objection
Jones.
as to hearsay?
Response.
I believe this is gonna be for back on the listener, sorry.
So if anything will be used for effect on the litter not being made for truth of the matter, we'll wait to hear from the actual officer who did the arrest. But so I will not use it substantively at all. With that understanding, the objection's overruled, but it's not being used for anything substantive.
Thank you, Your Honor. Go ahead, officer.
I was advised by Officer Jones that a subject in his back seat needed something to get his child looked at. Was worried about their child.
Okay, and what was so he was in the back seat of a patrol car, is that correct?
Yes.
Had he been put in handcuffs at that point?
Yes, he was.
What was his demeanor in the car?
As soon as I opened the door, he started screaming at me nonstop. I could not get a sentence in. I couldn't get words in at all. I couldn't try to talk to him. He just cussing me out, telling me to let him out of handcuffs. He didn't do anything wrong. He needed to go check on his kid. I told him, I was like, hey, can help you with your kid, but you have to stop yelling at me. Obviously, communication works both ways. And I could not communicate with him at all, just screaming at me nonstop.
And at that point, had anybody obtained his name?
No, he wouldn't tell me his name, wouldn't tell any other officers his name, wouldn't even tell me where his kid was at.
Okay.
So I couldn't get.
And why were you concerned about getting his name?
Well, anybody who was in the backseat of a patrol car in handcuffs was a person of interest at that point for either being involved with that fact. There's multiple people running into the apartment that officers told me that you saw that person in. And so people change clothes all the time. So I needed to just calm the scene down, making sure I get people's names so I can get Officer Stover over there, try to get a better idea.
Okay, and were there any other incidents with Mr. Jones during your interaction with him?
Yes, there was multiple incidents.
Can you describe a couple?
First one was, I closed the door the first time I was talking to him, because I just needed, at that point, just to calm down, have him calm down, maybe we can just take a second. Open the door again, he's still screaming and yelling at me and stuff, so I'm telling him, like, hey man, this is serious, we're kind of dealing with a serious situation, someone's shooting off a gun. I need your name, or at this point, you're gonna go to jail. There's too many people running around here, I still gotta make sure we have people coming from mutual aid East Lansing, MSU, so many cops. So I just want to make sure people are safe. Still screaming at me. And so at that point, he's told that he's going to go to jail. He immediately kicks his foot into the door frame and just jams the door open. So I go over on the other side of the door and pull him inside by his shoulder because he was not listening to our commands to get in the back of the vehicle at all. He was just screaming and yelling the entire time. Later on, the doors were closed. This was probably about like 2 minutes later. I heard him screaming, "I'm having a heart attack, I'm having a seizure," repeatedly. And so I saw the door being opened and his body just jumps from the back of the vehicle. At that point, we have to put him back in the vehicle. He's screaming and yelling and everything. He then gets, when he's in the vehicle, get the one door closed. He kicks off that door and tries to headbutt me and outside of the vehicle. So I have to push him back in the vehicle. And then he's handcuffed, gets on his feet in the squatting position, growls and starts laughing.
I have nothing further, Your Honor.
Thank you. Cross-examination, Ms. Robinson.
Yes, Your Honor. Officer Moore, you were dispatched into the area for a shots fired complaint, correct?
Yes,
And that was a shots fired complaint for shots coming from a vehicle.
yes,
And that was at this apartment complex, correct?
not apartment, parking lot, yes.
But it was of an apartment complex, correct?
Yes,
Okay, so there were multiple units that were accessible from the parking lot.
those, yes.
Okay, so there were a bunch of people outside as well when you approached, correct?
Yes.
Okay, so it wasn't just Mr. Jones.
I was never there, and then immediately Officer Stover was the first person on the scene. He got over the radio and said, someone just ran inside wearing all black man wearing all black.
Okay, and so there was somebody that ran from the car that was wearing all black, correct?
Yes,
Okay, what was Mr. Jones wearing?
I do not recall.
You don't recall? Would anything refresh your recollection?
I had a still shot of my body cam footage, or then yes.
You're gonna have to give me a second because my computer died, but I can get that for you. It's not in this report. But my
I
computer-
mean, at this point, people can stipulate that Mr. Jones was wearing a jacket that was red and black. If that's
Red and black
sufficient.
jacket?
Yeah.
Thank
All
you.
right.
My computer decided.
All right, so pursuant to stipulation, Mr. Jones was wearing, or the defendant was wearing a red and black jacket.
Okay, so what Mr. Jones was wearing didn't match the description that you received from Officer Stover at the day of the arrest, correct?
Clothes can be changed very quickly when there is.
That wasn't my question. My question was if he wasn't wearing what matched the description of
Oh, no, he
Officer
was not.
Stover. Thank you. All right, so when you were there, you said that you assisted with Mr. Jones's arrest. So he was already in handcuffs by the time that you became involved, correct?
Yes,
And when he was in handcuffs, he was already patted down.
I have no idea about that.
Okay, so he was placed into a patrol car, correct?
Yes,
And he wasn't patted down before being placed into a patrol car?
I have no idea. I was not the one that had contact with them, put him in handcuffs or anything before that, so I have no idea.
So is it standard protocol though for somebody who is being arrested and being placed in the back of a patrol car to be patted down for weapons?
Patted down searched, yes.
Okay, so presumably if protocol was followed, then he would have been patted down for weapons before being placed in the vehicle.
Yes,
Okay, so if he was placed in the vehicle, that meant that he was unarmed.
I have no idea. I don't want to speculate or anything. I was not the person that did that at all. I don't want to say anything that would make it seem like it was.
Well, my question is if protocol were followed, if he was in the back seat.
Your Honor, I think as Mr. or Officer Horger said, this is speculating.
But well, he can indicate through his department what protocol is, but I get that he was not there. He did not make the arrest, so he can only indicate that's protocol.
Yeah.
Right? So with that understanding, I'm going to overrule the objection. It is protocol, but the court understands he was not there.
Okay, so per protocol, somebody would not be armed if they were in the back of a patrol vehicle, correct?
Correct.
Now, at that time that he was arrested and placed in the back of the patrol vehicle, Was he under arrest for any crime at that time?
I did not know at that time.
So when you approached Mr. Jones, he was in the back of the police vehicle. How long were you talking to him for? About how long?
Talked to him in 3 different occasions that were pretty consecutive. Couldn't get a lot of words in. I had contact with him for about like a few minutes, so two minutes.
Okay, and each of these 3 occasions, he was handcuffed in the back of the patrol vehicle, correct?
Yes,
Okay. Stated at one point, he started screaming at you.
yes,
And then at one point, you said that he was going to go to jail, correct?
yes,
And then that's when he was placed under arrest, correct?
for me, yes,
Okay, so that's when you arrested him, is when you told him he was going to jail. You then placed him under arrest. He then kicked the door of the patrol vehicle, correct?
yes,
Okay, not before you arrested him.
correct.
I have nothing further.
Thank you. Any redirect, Ms. Wilson?
No, Your Honor, thank you.
May this witness be excused from the people?
You may, Your Honor.
From the defense?
Yes, Your Honor.
All right, thank you, Officer Moore. You can leave the stand. And Ms. Wilson, you may call your next witness.
Thank you, Your Honor. The people would call Officer Jamil Jones. It sounds like he's running from another courtroom.
All right,
over
so-
here.
I know,
Like-
I know.
So he's testifying in another.
Yes.
court. All right. So let's stand by to wait for the other witness to come from the other courtroom. Is there anything in the interim that you wanted to put on the record?
I don't think so.
All right, so
I think he was like on his way.
All right.
So. No.
right, obviously not the guy we were looking, Mr. Carter. All right, yeah, we can.
Oh, there he is.
All right, Officer Moore, you can come up here.
Jones.
Jones. Officer Jones, you can come up here.
Yeah. No, you're good.
All right, you can stand right there and please state your first name and last name and spell them both for the record.
Jamil Jones, Jameel, last name Jones, Jones.
All right, please raise your right hand. Do you solemnly swear affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, go ahead and have a seat. The microphone is for recording purposes, as you know, so please project as best you can. And let me know if that fan's bothering you, sir. Ms. Wilson, you may proceed.
Thank you, Your Honor. Officer Jones, where do you work?
City on Lansing.
And what is your job title?
I am a police officer,
What are your general duties?
protect and serve the community, enforce rules and regulation, ordinances, and state law.
And are you assigned to a specific division?
Patrol.
Patrol? Okay. Were you working as a Lansing police officer on May 6th, 2024? What were you wearing?
My fully issued uniform.
And is that what you're wearing today?
Yes.
Okay. And is that department issued?
Yes.
All right. And on that May 6th date, were you dispatched to 4833 at Dunkel Road?
Yes.
Is that in Lansing,
Lansing
Ingham County,
County,
Michigan?
Michigan.
And what were you dispatched there for?
I was dispatched to a vehicle that the previous day was fleeing from officers. The next day, that vehicle, same description, was in the middle of the street, I guess doing donuts. And according to the information that I received, there were with allegedly gunshots.
Okay. And did you receive any information about the suspect?
I was over the radio, it was broadcast that suspect was fleeing from another officer.
Okay. And did they say where he was fleeing to?
Department.
Okay. Now, when you arrived, what was happening?
When I arrived in my patrol car, I noticed a large crowd outside. A lot of commotion, a lot of arguing, a lot of screaming. We end up conducting like a perimeter around the apartment complex and trying to get the large crowd that was making a lot of noise, arguing, to come towards us.
Okay. And at some point in that evening, did you make an arrest?
Yes.
And what did you arrest that person for?
RTR.
And what is that?
Sorry.
You're good.
RTR is I can't remember. Sorry.
Can you describe the general actions that he was doing that led to the arrest?
Yes. So he was doing basically he was kicking around in the back of my one of the patrol vehicles, attempting to escape, kicking out officers, screaming, and trying to escape the patrol vehicle from our custody.
Before he got into the patrol vehicle, had you detained him?
Yes, he was detained. He was also informed that we're basically trying to eliminate him as being the potential suspect because the alleged suspect ran inside the apartments or the complex or townhome. And when another officer got there, I noticed individual coming out of the same area vicinity and started walking towards officers while he was trying to basically identify and eliminate. So as he got closer, he was detained, placed in the back of my patrol car, and was informed that he's not under arrest, he's just being detained until we can identify if he's the suspect or not.
And at some point, did you get his name?
At some point, we did identify him.
Okay.
Yeah.
And do you see him here today?
Yes.
Can you point out, describe something he's wearing?
Wearing locks with beard, black coat.
Your Honor, for the record, I'd request for the identification be.
Any objection to the witness identifying the defendant for purposes of prelim, Ms. Robinson?
Not for preliminary exam.
Thank you. So the witness has identified the defendant for purposes of prelim. Ms. Wilson, you may proceed.
Thank you, Your Honor. Now you said that when he was in the back of your patrol vehicle, he was kicking around. Were you involved in any of that?
Yes.
What, can you describe that a little bit?
So for the record, RTR is response to resistance. Sorry.
No, you're good.
I worked overnight the night. So what he was doing in the back of the patrol vehicle was screaming. He was talking about his kids being alone in his apartment by himself in the dark. He began to say that he needs medical attention because he stated he was having a heart attack, seizure. So I opened up the rear door of the patrol vehicle, and that's when he began to try to escape.
And did you or anybody else say anything when he was trying to escape?
I can't.
Okay. At any point, did you give him any sort of command?
Yes,
What was that?
yes. It was something along the lines as stop resisting, or call a medic.
Okay.
But his intention was to use the medic attention for escape.
Okay. And when you said stop resisting, what was he doing?
Objection, judge calls for speculation.
Response, Ms. Wilson. You can indicate what he saw.
Yeah, what he saw is fine. Yeah.
All right. So the objection sustained, and you can indicate what he saw and what he did in relation to the resisting and obstructing count. You may proceed.
Thank you, Your Honor. So when you were saying stop resisting, what was he doing?
He was at that point, the door was open. He basically locked his body out like in basically straighten up. His legs was locked. His foot was kind of like underneath the back door, so preventing officers from being able to safely put him back in the patrol vehicle.
And when you told him to stop, did he stop?
No.
Okay. I have nothing further, Your Honor.
Cross-examination, Ms. Robinson.
Officer Jones, when you arrived on scene, were you one of the first officers that arrived at the location?
No.
Okay, so when you arrived on scene, what, if anything, did you first initially see?
When I arrived on scene, I initially witnessed one of the other officers taking a point at one of the corner of the apartment complex, a townhome area, and another officer taking another point to the back of the apartment complex or townhome area. It was relayed that the alleged suspect went into one of the sliding doors.
And there was multiple people that were outside, correct?
More people outside, a lot of arguing, a lot of seemed to look like there was a lot of confusion from the bystanders, the people that was like in the grass on the yard.
Okay. And so when you came into contact with Mr. Jones, he walked out of the back door of his apartment, correct?
Yes.
Okay, so he walked out of the back door of his apartment and then he was immediately handcuffed.
Not immediately handcuffs. He was instructed to get back into his house, but he continued to walk toward the officer that was first on scene, and that officer instructed him to come towards him. At that point, he was detained, placed in handcuffs.
Okay, so the officer told, as Mr. Jones exited his apartment, another officer told him to come to him, correct?
I was in the original of the first one on scene. I can't say I'm part of the third or fourth.
Okay, so were you next to him when he was handcuffed by the officer?
Yes.
Okay, so you saw
And
Mr.
he was cuffed by me.
And he was cuffed by you. Okay, so as soon as he approached you, you handcuffed him.
Yeah, the other officer was able to obtain one of his arm out, obtain the other arm, place him in handcuffs. And then he was detained at that point, and we instructed him or informed him that he's just been detained until we can figure out what's going on.
Okay.
Because he walked out the back of the apartment. We didn't know if it was actually his apartment or the apartment that the alleged suspect ran into, based off the position that he was at, the angle.
Okay, so you handcuffed him. Did you pat him down as well?
He was found.
Okay, and was anything found on him?
No.
Okay, so after he was,
Call that part.
no, nothing was found on him? Okay, so then he was placed into a patrol vehicle, correct?
Yes.
And when you arrived on scene, the call that you received was for reckless driving and shots fired, correct?
Yes.
And at the time you handcuffed him and brought him to the vehicle, was he physically resisting at any point in time?
Not recall.
Would anything refresh your recollection?
Um,
Well, would reading your report refresh your recollection? Presumably you would put in your report if he resisted you. May I approach?
You may.
So this is your report. You can go ahead and look it over, and when you, if you feel refreshed, you can go ahead and just turn it over. Did that refresh your recollection? Okay. So was he physically resisting you before he was placed in the patrol vehicle?
No.
Nothing further.
Thank you. Any redirect, Ms. Wilson?
No, Your Honor, thank you.
May this witness be excused from the people,
Yes, he may.
from the defense?
Yes, Your Honor.
Witness, you're excused. Thank you for your appearance today. Any further witnesses from the people, Ms. Wilson?
None for the people, Your Honor, thank you.
All right. Any proofs today from the defense?
Possibly 1 second, Judge.
No. No, he wasn't subpoenaed. And I don't think he's started any other cases.
Then, Judge, based on the testimony that's been provided today, I think that I would like to call another officer. Apparently they weren't subpoenaed, although they were one of the main officers that was involved in the investigation. So at this time, I'd like to be asking for a continuance.
All right, so the request is a continuance to subpoena, and what officer would you be subpoenaing?
Officer Stover.
Sir Tyler Stover. And so at a preliminary examination, the defense has the ability to subpoena witnesses. This was not a subpoenaed witness, but now after testimony, the defense is requesting that Mr. Stover be subpoenaed. Any objection to an adjournment? We've started the prelim. So any objection to the adjournment will allow the defense to subpoena Officer Stover for purposes of the second part of the preliminary examination. All right. So let's adjourn the prelim for defense witness subpoena Officer Stover. We'll adjourn the prelim to
July 11th at 9.
July 11th at 9 o'clock. I don't know Officer Stover's vacation plans.
I do not either.
But we'll wait to hear if he's able to answer the subpoena, if there's a conflict, but we'll set it for July 11th at 9 o'clock for a continuation of the prelim. So at this time, we've heard from witnesses 1 and 2. We're waiting to hear from witness 3, and there have been no exhibits submitted. Is that correct?
That's
All right.
correct, Judge.
All right. Anything else for the record? So we'll adjourn to July 9th, July 11th at 9 o'clock. Anything else for the record in docket 24-01368? Ms. Wilson.
Not for the people.
Ms. Robinson.
No, Your Honor, not this time. Thank you.
All right. So Mr. Jones, we'll see you on July 11th at 9 o'clock to continue this prelim. All right, sir? All right. Anything else for the, that's all for the record. Thank you, everybody, for your appearance. then that subpoena will come from the public defender's office.
I think so.
I would think that's their
I
witness.
mean, I don't intend to call him,
Right.
so.
Oh,
sorry.
They're in the file. I
They're in
bet,
the
I
file?
bet you they're in the file.
All right.
So you want to take those out.
I do.
For a second, I realize you're faster than I am.
And then we have,
And then if we can bring up
Do you want to
LaVoy,
do Bruton?
yeah, well, I
Okay.
was gonna do Bruton while we're waiting on, while
All right.
LaVoy's been brought up.
you want to do Bruton in the interim. Yeah.
Your officer's not here, right? Okay.
All right, so we're on the record in 240154. That's people of the state of Michigan versus Jason Bruton. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Aaron Robinson, Assistant Public Defender for Mr. Bruton.
And sir, you are Jason Bruton, is that correct?
Yes, Your Honor.
All right. This is the time set for preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. We had continued this exam for testimony from Officer Ryan Lawrence. I was informed earlier this week that Officer Lawrence is at a training today. So I'd be requesting continuance with the understanding that the court's heard some testimony already.
All right, let me see if I have any notes on Mr. Bruton's case from the first. Bruton. So there was we started this prelim as to Mr. Bruton. Have preliminary examination started with Officer Smith?
With Letitia Smith, she is the complaining witness in the matter.
I might have those on my desk. All right, and the request today is for an adjournment of the matter. We adjourned for further testimony on June 27th at 9:30. And your officer is not here.
That's correct.
All right. Response, Ms.
Yes, Your Honor, I would be asking for the court to dismiss at this time. The first preliminary exam date, it was continued because the officer was not available as well on that date. I know the court had some scheduling conflicts as well, but we were actually able to get that preliminary exam in and started. However, the officer wasn't available on that date, so we reset it to today's date, and the officer again isn't unavailable. So I would be asking the court to dismiss at this time, excuse me, I can't speak, with the understanding that the state can refile charges if and when they're ready.
Thank you. So this was that we started the preliminary examination. There was the officer, and it's Officer Ryan Lawrence,
That's correct.
and he was subpoenaed to be here today,
He was,
and then he has got a conflict.
he was here at the last exam, but if the court remembers, we were pressed for time and I wanted to get my lay witnesses on all the cases done. So we were kind of just continuing some cases. And then I received word earlier this week that he had a training set for today, and it was some kind of training that if he missed even a portion of it, he wouldn't get certified for whatever it is.
All right. And I don't believe that witnesses waived any, this has all been, well, we started the prelim, so there's. And Mr. Bruton is out on bond at this time, is that correct?
That's correct.
Do you know the officers, I'm asking way too much here.
No, I did not
All right.
ask for his schedule.
Well, I'm going to grant the adjournment for conflict. The witness was subpoenaed and then came in contact with the prosecutor's office saying that there was training. We've already started the preliminary examination. So we're just waiting for that next witness. Mr. Bruton is out, so we don't have an incarceration problem. And I will reset. But we're running out of time,
Yep.
as you know, obviously. We reset the preliminary examination and the final witness.
The complaining witness was not released as Ms. Robinson indicated she might call her for her proof. So she is here today, but obviously if we don't have the rest of my witnesses, so
Right.
it may be 2 witnesses next time, depending on what happens.
All right, so Ms. Smith is here.
Yes.
And so she stays under subpoena.
Yeah.
That's my understanding. Okay, so Ms. Smith stays under subpoena. And then we'll adjourn for Officer Lawrence and possibly Ms. Smith on to be cross-examined once again by defense counsel or called as a witness. And we'll reset the prelim, I should say continuation. For
July 11th at 9:30.
all right, we'll reset for July 11th at 9:30 for possibly the witness Smith to be called, and then for continuation for Officer Lawrence to answer the subpoena. Anything else for the record? 24-01542, Ms. Wilson,
After the people.
Ms. Robinson.
Your Honor, briefly, for Mr. Bruton, he does have a tether on for this case. I understand that this case will be then going on for, a little bit over a month. At the time for his preliminary exam date, we would be requesting removal of the tether. He is willing to abide by all the other bond conditions. There hasn't been any allegations at this point that the bond terms have been violated. So we would be asking for that. It has been an undue financial hardship for him.
Ms. Wilson.
I know the complaining witness has expressed that she doesn't want a no contact order with Mr. Bruton. Based on that, I'm a little concerned about removing the tether, because if she's not going to keep herself away from him, then there's a question of whether he's going to violate that. So I am a little concerned about that.
All right, so, well, I think Ms. Smith did indicate that she
Yes.
wanted to remove the no contact order. Let's just keep this on hold till July 11th, till we see where it lands, because I have some same concerns. I understand this is a financial hardship because we are looking at a GPS device, but Ms. Smith has indicated that she wants to see the defendant. And so let's just hold off till July 11th at 9:30 on all that. So the motion to modify bond is held in abeyance or under advisement until that July 11th date, and that we get everybody here and we'll see where we go from there. So motion to modify bond is held under advisement until July 11th. Anything else for the record in docket 24-01542, Ms. Wilson?
Not for the people.
And then Ms. Robinson will revisit the GPS on that July 11th date.
Yes, Your Honor.
All right, thank you. That's all for the record in that file.
My copy or his copy?
He's got it.
Okay, thank you.
And,
All right, Gail tag.
all right. I'm not gonna get an argument from Gail on that.
I'm sure not. I'm just leaving it in with me until you get a chance to become yourself.
So Wendy,
Oh, boy.
Oh, this is a good question,
are
yes.
we able to send writs to 2 different counties? If we don't know which county he's gonna be in?
Yeah, well,
More of a question for LPD, if they'd be willing to check it.
Okay.
I'm more than willing to do 2 writs.
Yeah.
However, I think it should be defense counsel to call and let us know so we know where to send our officers.
Yeah,
Okay.
and Ms.
I
Schroeder
don't want
plans
to,
on it.
yes.
I don't want to send them to 2 different
Right.
locations.
We just don't know.
We just don't know which one he's gonna be in.
Oh, I totally get
Yeah.
that.
Yeah.
Just do I have a minute to shut this down and? plug it into
Absolutely,
me?
yeah.
Thank you. I wasn't sure where we were with that.
We have
document.
Mr. We have Mr. Lavoy and
Yep.
Mr. Newby
Yep.
are left.
Okay.
And Mr. Newby is a continuance.
Correct.
And then Mr. Lavoy may be going on his own depending.
Yes,
Possibly.
I would suggest doing him last instead of a him.
All right,
Oh, okay, we can finish newbie then.
all right.
I have to run to another boardroom.
Got
Okay.
any hard candy up there?
No.
Yes, yeah.
Are you
I
running?
know.
I have candy.
Yeah, we're gonna finish newbie.
Okay.
It shouldn't be too
I'm just gonna
long.
put my stuff under
Yep.
here then.
You are counsel on Newby, Mr. Carter, right?
Yes, I represent.
The witness.
Yes.
I will have this back
It's
up.
already
Yep.
I think Gail's already given me notes.
She has, okay.
Yeah.
Perfect. I don't see that.
Yeah.
Just a second. This comes back up.
Perfect.
Yeah. Yeah. He's not real happy right now. No. He's having more. Oh, really? Yeah. He took it better than I thought. But he's. No. And his mid is lower than the rest of the problems. He goes, well, I can wait. I'm waiting for the fat cheese buddy. Well, he's already on restriction, and this is only gonna add 2 weeks to his restriction. It's stupid not to do it now. Right. All right, JRS, come on. Is Mr. Moody here? Yes.
Yes. And then Miss Wilson's gonna join us and then we'll, and we have counsel for the witness.
Oh, is that Mr. Carter?
Yes. He's been here since 9,
Oh.
but we had a lot go today.
Did they find the court reporter notes when they handed you Mr. Newby's stuff?
She just gave me my notes.
So none of my stuff is attached, okay? I don't remember starting. How many witnesses did we already have?
One or two?
But they not, we're not
Yeah,
done,
we have Officer Antonio Lina.
not done with any of them.
Okay.
Okay.
So we have done Officer Lina, but you have not crossed him,
I
correct?
have not.
All right. So we're on the record in docket 24008888. That's people, the state of Michigan versus Zachary Newby. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Wanchi.
Assistant Public Defender, Melanie Dewanchi, Commissioner Newby.
All right, and sir, you are Zachary Newby, is that correct?
Yes, sir.
All right, thank you. this time set for, a continuance of preliminary examination. It's my understanding that we asked for a continuance for cross-examination on Officer Lena. Is that correct?
Officer Cena, and then also a continuation of direct for Miss Harrington.
Miss Carrington, and
Yeah.
then we
And
appointed
conflict
counsel,
yeah.
or we have a conflict counsel. So Mr. Carter, your appearance for the record.
May it please the court, David B. Carter Jr. on behalf of Miss Harrington, who is present and not in the
All right,
the sequester
all right. And you had the opportunity to discuss any
several times
with Miss
and plenty of time.
Miss Harrington. All right, all right. So Miss Wilson, I'll leave it in your, we're under cross on Officer Cena.
Yes, and I have not finished on Miss Harrington yet. I just have a few more questions. So I
All
think
right.
I'm gonna call her first.
So go ahead.
And can I republish my previous exhibits?
Yes. And those were already admitted.
Yes.
Your Honor, I'm gonna want to make a small record.
Yep.
Yeah, before.
Yep.
So with Miss Harrington,
She in the library?
so we have exhibits 1, 2, 3 have already been admitted. And then Mr. Carter, I'll let you make a record before she takes the stand. All right, Miss Harrington, you can come up here. I'm going to re-swear you in. So Giles Harrington, I'll have you state your first name and last name and so spell them both for the record.
J.L. Harrington, spelled J.A.E.L.H.A.R.R.I.N.G.T.O.
Okay, once again, I'm going to raise your right hand. You solemnly swear affirm to tell the truth, the whole truth, nothing but the truth under penalty of perjury.
Yes.
All right, ma'am, you can have a seat. The microphone is recording. Please project as best you can to the back of the courtroom. And then prior to any statement being made, I'll let Mr. Carter make a record. Mr. Carter was appointed for purposes of your testimony. Mr. Carter, you may proceed.
Thank you. Ms. Harrington, you're a witness in the case against Mr. Newby, is that correct?
Yes.
And during your first time you were in court, you had taken the stand and you were testifying, isn't that correct?
Yes.
And at that time, there became an issue of whether or not you may need to seek counsel in order to advise you on your right to remain silent and not incriminate yourself, isn't that correct?
Yes.
And I had talked to you, I was appointed to you, I had talked to you over the phone at one point, and then in court at the last hearing, and then even today, isn't that correct?
Yes.
And we have gone through your rights to remain silent and not incriminate yourself. Isn't that correct?
Yes.
I have given you the pros and cons of what may happen one way or the other. Isn't that correct?
Yes.
And it's your desire to continue to testify. Is that correct?
Yes.
I have nothing further.
All right. With that understanding, Ms. Wilson, the witness has been re-sworn in, has addressed any of her Fifth Amendment rights with counsel, and Ms. Wilson, you may proceed.
Thank you, Your Honor. So Ms. Harrington, I believe the last time we were here, you had identified the individual to my right, with the ponytail as, Zachary Newby, your boyfriend or significant other. Is that correct?
Yes.
Okay. Can you tell me, how long have you guys been together?
About 4 years.
Okay. And, are you currently pregnant?
Yes.
Do you know who the father is?
Yes.
Is it Zachary?
Mhm.
Okay.
Sad, yes.
Is that a
Yes.
Oh, sorry. And, were you guys living together prior to this incident?
Yes.
What were your financial arrangements like?
At the time, I wasn't working. So he was the one responsible for bills and stuff at home. He was working full time.
Okay. I have nothing further. Your Honor.
Cross-examination, Ms. Wanchi.
Thank you. Good morning. So, what at your the last time you were here in court, you stated that you were mad at my client, correct?
Yes.
And the reason why you were mad at him is because you had found some text messages on this one,
Yeah.
and the text messages made you very unhappy.
Yes.
And so you and because you were very unhappy that day, you start drinking. Is that correct?
Yes.
And you start drinking to the point that when he came home, you were wasted.
Yeah.
And you were supposed to, he came with his friend, correct? And his friend
Said
was,
yes?
Yes.
Okay, thank you.
and his friend
I'm
was.
sorry, Your Honor. I just, if we can go back and define wasted, just because it's kind of a colloquial term. Like,
So-
I think I understand what's being said, and I
Right.
just want to make it clear.
So Ms. Wanchi, if you want to clarify it as to the witness's description or your leading question as to wasted, what that means.
Well, you had drunk a lot that day.
Yes, I did. So I believe I drank pretty much a whole fifth of vodka that day to myself.
And when you came home, when he came home, you were drunk. Is that
Yes.
correct? And you were supposed to do his friend's hair, daughter's hair that day,
Yes.
but you did not do it.
No,
You were not able to do it.
no, I wasn't. Yeah, I wasn't physically able to do much of anything. But
And you when he came, you start having you start attacking, well, you start having arguments with him.
yes.
You did not tell him why you were mad? Or did you?
Can't remember exactly what I said, but I know I already was in a pissy mood and I kind of just let that keep the ball rolling, and I was taking my anger out on him and started arguing it.
And you call him the B word in front of his friend? That's
Yes.
what that, okay. And he told you that he's leaving.
Yes, he tried to.
So and when he cried, he started getting his stuff from the closet.
Yeah, gathering his belongings.
Okay. And you didn't want him to leave.
No, I didn't.
And you, when he was gathering his stuff out of the closet, you launched at him. You did not want him to get his stuff. Is that correct?
Yes, I tried to grab his things out of his hands and stop him.
Okay. Is it fair to say that you were the one who touched him first?
Yes.
And that you touched him because he wanted to leave and you did not want him to leave?
Yes.
You had you told the police that he choked you. Is that correct?
Yes, I did tell the police that.
Okay, and did he choke you?
No,
The only time he tried to touch you was because he was keeping you away from him. Is that correct?
Yeah, it was more so trying to restrain me and stop my attempts of coming after him.
Yeah. Do you recall falling down that day in the Christmas tree?
I do
Okay,
multiple times, actually.
okay. So you fell on the Christmas tree that day, correct?
Yes.
And you did not tell the police officer that you fell on the Christmas tree.
No.
You actually said that he's the one who pushed you,
Um,
or something like that. He was the cause of you falling down. But let me rephrase.
Sorry,
He did
what
not
was it?
push you.
no, he did not.
When you fell on the Christmas tree, he did not. touch
No,
you.
that was my own drunk standing, or
Okay.
trying to stand.
Okay,
I also fell down my steps and in my bathroom at one point.
okay. So he did not touch you when you fell in the bathroom.
No,
Okay, but you did not tell the police about that.
no, I did not.
And you recall also falling inside your bedroom,
Yes,
missing the steps.
yes,
And it's because you were launching at him and you missed the steps.
yeah,
But you told the police that he's the one who pushed you and that it caused you to fall. Is that correct?
yes. I did.
You grab his keys. Well, he was trying to leave. At one point, he got his stuff and he was trying to leave through the back door. Is that correct? Do you remember that?
Yes,
And you went after him
yes,
and he was closing the door
yes,
and you pushed the door.
yes.
And say it again.
Yes,
And when you pushed the door, both of you fell on the rail.
yes.
He did not push you on the rail.
No, he didn't.
When you fell on the rail, sorry, you fell on the rail, you bumped your head on the cement. Is that correct?
Yes,
When you told the police that he's the one who banged your head on the cement, is that correct?
yes.
That was not true.
No, it was not.
When you fell, you hurt yourself on your knees,
Yes, I did.
okay? But did it have anything to do with you hurting yourself on your knees?
No. I believe it's from the gravel stuff outside.
Okay. You took his car keys and left with his car, is that correct?
Yes, I did.
And you said you told him that because you were scared,
Yes, I did.
that you were scared for your life.
Yes.
That was not true, correct?
I'm sorry, what was that?
That was not true.
No, it was not.
You took his car because you didn't want him to leave.
Yes,
And you told the police that you left, well, you left and you came back. Is that correct?
yes.
And if you were if you fear for your life, you would have not come back to the place where you were afraid for your life. Is that correct?
Yes,
But you came back
yes,
and you changed to cars and you took your car and left.
yes.
When Mr. Newby came home, he was not drunk, correct?
No,
He has not drunk that day.
no,
His friend either was not drinking.
no, they
You were
don't.
They don't drink.
No.
Okay. You did not tell the police, well, that first officer, you did not tell him, the officer who interviewed you at the hospital, you did not tell him that you've been drinking. Is that correct?
No, I don't.
You told the other officer.
Yes,
Okay. And you say you also had a fracture pin toe,
yes.
and that it has nothing to do with, you did not recall how you got it.
No, I believe it's from the steps when
Okay,
I was falling around.
okay,
Like stubbed it on something.
okay. Did Mr. Newby ever slap you?
No.
When you called him the B word, he did not choke you at the time.
Asked and answered, Your Honor.
I'm gonna sustain it.
He did not slap you.
Asked and answered, Your Honor.
No.
He did not punch you.
I'm gonna sustain it. I think you asked all these questions already.
He did not kick you
Asked and
in the
answered.
back or on the
I don't think she
side.
asked if he was kicked.
No.
But you had some fracture on your, but your ribs was hurt. You were hurt on your ribs, correct?
Yes.
And it had nothing to do with him.
No.
So at the end, you're the one who was the aggressor in this case, is that correct?
I'm sorry, what was that?
You were the aggressor.
Your
You- the
Honor,
one who
I'm
stabbed.
gonna object. That's ultimately a legal conclusion here.
She can ask if the witness believes that she was the aggressor.
Do you believe that you were the aggressor?
Yes.
I have no further questions.
All right. Thank you. Any redirect, Ms. Wilson?
Yes, Your Honor, thank you. So, Ms. Harrington, you went to the hospital the next morning, is that correct?
Yes.
And you provided a statement to the nurses at that hospital, is that correct?
Yes.
And you provided a statement to police officers at the hospital, is that correct?
Yes.
Okay. Now, there's been some testimony that you had been drinking, but that was the night before, is that correct?
Yes.
Okay, so by the time you got to the hospital, you weren't under the influence, is that correct?
Yes, I
Okay.
maybe hungover, but not drunk.
Okay, and you went to the hospital right after the incident, correct?
No,
The next morning though?
yes,
Okay, so within a short period of time,
yes,
okay, and then so this happened in December of 23, correct?
yes,
And here today, it's June of 2024, is that correct?
yes,
So it's about 7 to 8 months later?
yes.
Okay, now, after this incident, did you reside with Mr. Newby until his arrest?
No, he was at his parents.
Okay, did you have contact with him?
We did speak a few times.
Okay, at some point, did you reconcile?
Yes,
Okay, and you're currently pregnant with this child?
yes,
And he was previously a large financial support for you, correct?
yes.
Okay. Your Honor, if I could have my exhibits real quick.
You may. So these are the previously admitted exhibits.
So Ms. Harrington, I'm gonna show you some photos here and they might be a bit triggering. I'm just gonna give you a heads up. I'm gonna show you people's exhibits 1 and 2. Okay, now these were previously admitted as photos that were taken of you at the hospital. Do you see some marks there on you?
Yes.
And those were not there before you went to the hospital, correct? Or let me rephrase. Those were not there before your altercation with Mr. Newby, is that correct?
Yes.
Okay. Motion to republish, Your Honor.
Motion granted. So they've already been admitted.
Nothing further, Your Honor.
All right.
What's regarding those pictures, Your Honor?
If I can have the opportunity to redirect afterwards.
So you'd like to cross on exhibits 1, 2, and 3 that were previously admitted? You may. You may.
I'm gonna give you back those pictures and ask you the questions. You testify that those injuries and causes, you did not have them before you went, before you met before Mr. Newby came home, correct?
Yes.
But he's not the reason why you got this.
No.
Okay, thank you.
A redirect of Ms. Wilson on the cross-examination.
No, Your Honor.
All right, thank you. May this witness be excused from the people?
Ma'am.
I have one request on behalf of
Sure.
my client. I don't know how this prelim's gonna go. I don't know how it's gonna pan out, but obviously my client is pregnant with the defendant's child. My client obviously would like the no contact order lifted And I understand the court's concern and all that. If the court's unlikely to lift the no contact order, I would ask that he be allowed peacefully contact to go to the doctors and hospital if in fact she goes into labor.
All right, that's a fair request.
I have a scheduled C-section date also.
Do you have the date
Yes, I
right
do.
now? What date is that?
August 22nd.
So it's scheduled for C-section on August 22nd.
But that same request is in because father of two, babies may come before the
Right.
scheduled C-section.
You are absolutely right. We have a date, but there's also the request is made. So anything else? May this witness be excused, Ms. Wilson, from the current subpoena?
No, oh, yes, sorry.
Ms. Wanji.
Yes, before she leaves, I would like to know whether or not, because I'm gonna make a request that my client's data be removed. And also the request that the no contact order be removed.
Okay.
So I would just want to make sure that.
All right.
she's not-
All right. With that understanding, do you have any, may this witness be excused? All right. This witness is excused from her subpoena at this point in time. And Ms. Wilson, you may call your next witness.
Thank you. I believe we're on cross-examination, but Officer Anthony Sina.
Okay. And Mr. Wilson, Mr. Carter, I think that ends your time this morning with us, right?
Thank you.
Okay.
It was a pleasure.
Yes. Thank you, Mr. Carter. And then we are under cross of Officer Sina, is that correct? All right. Officer Sina, we're gonna re-swear you in. I know you're already sworn in, but please state your first name and last name and spell them both for the court recorder.
Officer Antonio Sina, ANTONIO CENA.
Okay, I'll re-swear you in. Please raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, please have a seat. We are under cross-examination at this point, I believe, Ms. Wilson. So Ms. Wanji, you may proceed with your cross-examination of Officer Sina.
Thank you. Good. Morning.
Good morning.
Officer, everything that you were not at the home where the incident took place.
No, ma'am.
So everything that you stated were from what Miss Harrington told you, is that correct?
At the hospital.
Okay, and you did not, up to that point, you have not seen my client?
No.
Okay. I have no further questions, Your
Uh,
Honor.
Any redirect, or have you've already done your direct?
I've
Any
done my
redirect?
direct, no redirect, Your Honor.
All right. So Officer Sina, may this witness be excused from their subpoena, Ms.
He may.
Ms. Wanji? All right, you're all set. Thank you, Mr. Sina.
Thank you.
That was the fastest court thing. Motion for any further proofs, Ms. Wilson?
No, Your Honor, people rest.
All right, any proofs today, Ms. Wanji?
No, Your Honor.
All right, motion for bind over, Ms. Wilson.
Thank you, Your Honor. The defendant's currently charged with a count of strangulation. That is the felony count that is before the court here today. We had testimony at a previous exam as to the date being December 24th, 2023, and the location being 550 Norman, which is in the city of Lansing, Ingham County, state of Michigan. So I believe the date, venue have been met to a probable cause standard. Ms. Harrington did identify Mr. Newby as the individual she was in a relationship with and who she had this altercation with. So I believe to a probable cause standard, the element of identification has been met. Now, I'm perfectly aware that the court has heard some radically conflicting testimony here today. And I know the court is well familiar with the cycle of domestic violence, so I'm not going to belabor the point. But we have here a pregnant woman who was reliant on the father of her child for financial support, who is now without that support, is about ready to have a child 7 to 8 months after this incident, and is now changing her story. So I believe that here we have a situation where a victim is kind of boxed into a corner. She feels like she's boxed into a corner and she needs to get out of it. So I believe her statements at the hospital are the most credible. Her statements to the nurse, her statements to the officer were consistent. Her injuries are consistent with the statements that she made. And I believe that the elements here to a probable cause standard have been met. She did say to the nurse and to the officer that her breathing was constricted and that Mr. Newby did constrict her breathing. I know there's been some testimony that she initiated the contact here today. However, based on her previous statements, it's pretty clear that Mr. Newby was the aggressor, I believe. And I understand that the court's heard some very different testimony here today, but this is not an unusual situation. And I think if the court looks at her previous statements, the injuries, the court will see that to a probable cause standard, the elements here are met, and this case should be bound over.
Thank you. Ms. Wanji, argument in response.
Yeah, I think that the hold of the court also, even at preliminary exam, is to see whether or not there will be any success if the case is bound over to circuit court. We have a drastically, and I'm going to answer first regarding the support. This lady had already, since the first time she came, she wanted to change her to change her story and tell the truth. That's why that's why she had an attorney appointed for her. At no time since that time there has not been anything to show that she relied on my client. It's been almost 8 months. She has not, or since the beginning of the case, there has not been any contact. She has not relied on my client to eat, to live, to pay her rent. So to say that that she's changing her story because she's relying on my client for support, I think that is just speculation. And so, and even though she said that he was paying the bills, I don't think that there was enough foundation to show that without him, she would not be able to support herself. And there was also no evidence here that there were other instances of domestic violence and that she was the victim of, well, there was no evidence to show that she was the victim in this case. So we will respectfully ask the court not to bind the case over because she testified that my client did not choke her, did not hurt her, and did not cause all those injuries. And the reason, the explanation that she gave to the injuries are reasonable. There was no proof here that the way that she explained how the injuries came about were not the truth. The only thing that she did not tell the police was that my client, was not the one who caused all those injuries the way that she stated that he did cause the injury. He caused the injury during her testimony. So we will ask the court not to bind the case over because, again, the goal is also here is to find probable cause, but also to see what are the chances of the prosecution to win this case.
Thank you.
Thank you.
Ms. Wells, response.
Yeah, so first, we don't need other acts here. One act is enough. I just want to make that clear. And she wasn't working at the time. So I think if he left, if she doesn't have any money, that probably means that she can't support herself. Maybe she got a job later, but like we heard here today, she's about ready to have a child. She's probably going to be off of work for some time. She needs some help. She needs some help with the child. There is a motive here to walk back on her statements and to say some other things. And, the defense here is saying that because she didn't tell the officer that she was drinking, on that instance, that she's not credible, but that assumes that she's not truthful to the officer. And I don't think that's true here. I think that there's a possibility that she wasn't drinking and that now she's saying she is because of the circumstances that are going around it. I understand that this is a conflicting case, but this is the cycle. This is how these things go. And the injuries here were extensive, and her statements were consistent between the officer and the nurse. The consistency is here today, 8 months later, when she's about ready to have the defendant's child. So I think there is sufficient evidence here to bind over. And while I understand that part of the court's duty, I guess, is to determine the successfulness of this case at trial. Ultimately here, what we're getting down to is credibility, and credibility is so subjective based on the evidence that's presented, the order that it's presented in front of a jury. So I think ultimately that is an issue that should be left to a jury. There may be additional, I won't speculate. There may be an order of proof here that makes a jury think that she's lying now and she wasn't lying then. Who knows? But I think that the fact that we have some consistencies here and then now suddenly an inconsistency is not enough to quash this more. And I think that we should still bind it over.
Thank you. So over the course of two hearing dates, the court has heard testimony from Officer Sina and witness Jill Harrington and looked at exhibits 1, 2, and 3, which were previously admitted. It is a probable cause standard. And my reading of it is my reading of the case law that's been associated with probable cause standard is that really the probable cause standard is the second lowest, reasonable suspicion being lower than that. Ultimately, if there is a contradiction in testimony, the trier of fact has to figure out who they believe, unless it is so apparent that credibility is an issue. I don't find it is so apparent that credibility is an issue in this case. I believe that the trier of fact, the ultimate trier of fact, could look at more evidence and determine whether the witness is being truthful in regards to their activities on the date in question, which is December 25th, 2024, 24th, 2024, because the notification to the hospital was made the day after.
The morning after, that's correct, yes.
But it's as if there were two different events, okay? Miss Harrington has her responsible for all the activity. Mr. Sina has, when she initially reported it, Officer Sina indicates that all her injuries and so forth were reported that the defendant did that, and now it's completely changed, and that's why we got counsel to explain to her rights. There is a contradiction in this testimony that is almost as if it's two different dates. And with that understanding, I think that there is probable cause to find that the date of December 25th, 2024, the venue and location, so it's December 24th, 2024, the venue and location of the address on Norman Street, which I believe is in the city of Lansing, Ingham County, which is December 24th, 2023 at 550 North Norman, city of Lansing, Ingham County, have been met. Identification has been made of Zachary Scott Newby, and then the elements of the offense. I find that the report afterwards, there is evidence to indicate at a probable cause level that there was the assault with intent to do great bodily harm, less than strangulation or suffocation, pursuant mostly to the Domestic Violence Victim Statements Act, pursuant to 768.27C, which I don't know if is available at trial or not. This was a preliminary examination. It's a different hearing. Ms. Harrington did come and take the stand and indicate several defenses that may be at issue here. One may be an affirmative defense. She did question that. That is for the trier of fact to determine credibility. And so I find that the count 2 of the domestic violence will be follow up with count 1. But I believe the elements were made at a probable cause standard that the defendant did make an assault upon Jail Harrington by strangulation or suffocation. And I'll bind over on count 1. Count 2 will follow as a misdemeanor in that regard. So I will bind over as charged on count 1. And count 2 will follow. This court is not making a determination as to the merits of likelihood of success at trial, because I don't think that's in this court's purview, so to speak. I think most of the case law, or if not all, it may be a factor in some case law. In some case law, it's absolutely not a factor. Probable cause is the standard. And I believe that this court's duty is to let the trier of fact figure out the credibility of the witnesses and determining probable cause and determining now reasonable doubt in circuit court. So it's bound over as charged. I'll return the 3 exhibits. Now, as to, we do have the sensitive matter of bond in this matter that was indicated. So I'm going to indicate that the examination was held on May 30th and June 27th. And this is bound over as charged. We have a due date for the child in question on August 22nd, 2024, and then rightfully so, counsel's requested some peaceful contact with the child in regards to the defendant. The child, of course, is an infant, brand new, not a witness to this case. So any argument as to modification of bond, Ms. Wilson?
Thank you, Your Honor. As to eventual contact with the child once the child is born, I believe the court previously modified the bond conditions to allow for third-party contact regarding shared children. So I think once the child's born, that issue is kind of already taken care of. As far as during delivery, I made this argument before the court before. Delivery is an incredibly sensitive and vulnerable time for a woman. I have concerns about somebody who's accused of violence towards that person being present there. However, he is a father, and I get that the testimony here indicates that she wants him there. And now she's saying that it didn't happen, but I guess largely I leave it to the court's discretion. Ultimately, what I'm mostly opposing here is a lifting of the no contact order in general and a removal of any tether that he might be on. Those are the 2 things that I think absolutely need to stay in effect.
All right, thank you. Ms. Wanchi.
You hear the testimony of Miss Harrington. She's not afraid of him. The court may put as a condition that they don't discuss the case. These people have a family together. I don't know that the relationship is still there, but they still have to raise these children. He still has to be that she wants him there. She the one who wants the no contact to be lifted. We want the no contact to be lifted. I think that the court can ask my client that any contact that he has with her be peaceful. And I think that it would be enough. My client does not. It would be it would be an injustice here, based on the testimony that we hear here, that this case that my clients continue to pay for a case that may not, that for something that he's presumed innocent until proven guilty. The children are paying at this time for this mess. And these are the adults. I'm not saying that it's because of, but I think that the fact that it's also in the best interest of my client to have a peaceful contact with the mother of his children or the children to be. And if the mother, when she's having a baby, it's always able to tell the doctors who she wants in the birth room. If she doesn't want him that day, she can tell the doctor, I don't want him here. If she can, they ask the mother, who do you want to be here around you? So we want the opportunity for my client to go at the hospital. If she doesn't want him inside when she's giving the baby, that's her privilege, that's her right. But we believe that with the testimony that we have here, that the tether should be removed. My client has not violated any no contact order. He has not have any contact with her, he has not there is, and so we believe that if the court was to put a peaceful contact between the party, that would be enough. And again, if our client violates that, he's back, there will be a violation, there are consequences. But to continue to have him on terror when it's not needed, I think that is an injustice.
Thank you.
Your
All right.
Honor, if I might just respond,
You
because
may.
I have some issues with that argument here. The fact that we're standing here saying that a woman who's in the middle of labor, who's got an enormous amount of stuff going on, can then tell a doctor, hey, this man here who previously strangled me and broke my ribs should leave, is kind of ridiculous. The whole point here is that she may be afraid of him. I understand that's not what she's saying right now, but again, I go back to my argument for bind over. There's inconsistencies here. There's a reason here for some inconsistencies. So I don't like that. I'm not saying he can't be at the birth. That's up to the court's discretion. I understand that the birth of a child is a very momentous occasion. But to stand here and say, oh, she can just tell him to leave. No, she can't, because of what he's accused of doing to her. That's absolutely ridiculous. As for the peaceful contact, yeah, the court can order peaceful contact. Who's to say that's going to happen? I mean, and even if it is peaceful, who's to say he's not going to go home and say, hey, don't show up to court, so my trial gets dismissed? That's an issue. And so there's just a plethora of issues that could come out of him returning to the home or having contact. So I think the no contact order needs to remain in effect. I think the tether needs to remain in effect. If the court wants to allow him to be at the birth of the child, that's up to the court. But I just think we're opening a whole host of issues in ordering peaceful contact, because as the court's well aware, peaceful contact doesn't do a whole lot. It really doesn't. Thank you.
Well, the court bound over, so there's to the courts for probable cause purposes. And this can be revisited in circuit court, but I'll make the ruling that the no contact order does stay in effect. So there's a 2,000-foot exclusion zone for no contact with Gerald Harrington. The GPS still stays in effect. None of that changes based on the probable cause bind over. There was enough to bind it over, and so those will stay in place, including no possession of a firearm or dangerous weapon of any kind. The no contact has been modified as to the children at a previous hearing, which was at May 4th. We had a peaceful third-party contact for visitation purposes with other children that they may have in purpose. That stays in effect for the new infant once they're born. So that the bond is modified per the initial request on May 4th, that peaceful contact with a third party be part of that once the infant's born. As to the birth, which is scheduled for August 22nd, but may happen sooner, the defendant may be allowed to be a part of if the mother allows, may be in the room, cannot discuss the case, cannot discuss anything associated with the case, but may be in the room for the birth of the child, since the defendant is the parent of the child. I would allow that as part of the birthing process. But then once that birthing process is over, the no contact order comes into effect and he has to leave pursuant to the order, and even the modified order, which allows peaceful contact. I think the defendant should leave pursuant to the no contact order. And if it wants to make arrangements, can make arrangements to see the infant once they're born through our already modified order that was set on May 4th. So really everything stays the same except for the defendant may be present at the birth. That I find is reasonable, but the defendant, of course, if the defendant may not discuss any of this case, really the defendant shouldn't discuss anything concerning the relationship. They should just be there for the indication of the delivery of the child. But anything else, the no contact order, as soon as the child is delivered, no contact order relives itself this is my ruling and can be revisited in circuit court once the appropriate venue, circuit court venue is reached. So I will only modify the bond to allow the parent to have, the defendant to have peaceful contact at delivery to watch the delivery of the child. And then remove themselves in violation of no contact order. That's the ruling of the court. This is bound over. So your time in district court is done. You'll get your next date from Ms. Wanji in circuit court concerning your appearance in circuit court and what judge you're to appear in front of. And I will sign the bind over document accordingly. Anything else for the record in 2400-888, Ms. Wilson?
That's the people, thank you.
Ms. Wanji.
Nothing on it.
All right, you're all set. Your next date will be in circuit court, Mr. Newby. You're all set. Yeah, that'll be a transcript.
You seem so sure.
That'll be.
Sean?
Yeah.
It'll be something.
Sure how to modify the no contact order.
Yeah, we're gonna have to modify the 53.
Yeah,
and no
okay, I
contact.
didn't know if you wanted me to do it if you're gonna show.
Well, I'll do it because there's some very specific language. We're gonna have to quote word for word from his honor.
That's what I thought. You didn't want me to do it.
Did you want to save Lavoy? I mean, it's up to Miss Robinson, but we could do that during lunch or after. It's really up to you. You've got
So,
witnesses.
I mean, my
you've got
witnesses are
witnesses
here and they're already kind of pissed that they've
All
been
right.
here this long, so.
right.
If you want to wait 10 minutes,
All
we'll
right.
get you a copy of the new order saying you can be present at the birth.
Here's a request.
But that will be put into.
Signed by-
I'm not.
Yeah,
You guys tell me I can't. You should.
Circuit court signed
So leave it
that.
to them, but if they want to go, let's go.
Okay. The last I knew
Yes.
she was doing a waiver in Buchanan.
And
That was like
Mr. Lavoy's
45
got 2
minutes
files,
ago.
right?
Yes.
All right. All right, so let me know when you're ready
Yep.
and I'll take a break and we'll. I hear my iPad going off,
Yeah.
but we have to bring up Mr. Lavoy anyway,
Yes,
so
yep.
you should talk to his counsel a little.
Is he the one that wants the fire council?
Yep.
Yeah, he's going on his own today. Miss Robinson is gonna be standby counsel.
Okay.
The last time. introduce themselves for the record, Ms. Wilson.
Abigail Wilson for the people.
Mr. Sarvis.
Good afternoon, Your Honor. Jacob Starks, the Flores Assistant Public Defender, on behalf of Mr. Moore. Mr. Moore is present. He's at council table. He's seated, my right.
And sir, you are Emil Moore, is that correct? All right, thank you. This is the time set for a preliminary examination. It's actually a continuation of a previously started preliminary examination. Ms. Wilson, how are we proceeding today?
Thank you, Your Honor. My officers are here and we are ready to proceed.
All right, so we'll invoke sequestration. You can let me know if it needs to be, if there's one witness who can't testify to another witness's testimony. Any other preliminary matters, Ms. Wilson?
Just a little one, Your Honor. I'm just asking for a little bit of leeway on my continued direct with Officer Backery because I honestly don't remember exactly what I had asked him last time.
Okay.
So that's my.
We'll provide the same cross-examination for Mr. Sarves. All right. With that understanding, you may proceed.
Thank you, Your Honor. The people will recall Officer Jamil Backery.
All right, Officer Backley, you can come right here and we'll re-swear you in.
Okay.
So please state your name and spell your full name and your last name for the record.
Jamel Bakri. First name is Jameil. Last name is Bakri.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth under penalty of perjury?
I do.
All right. Please have a seat. Please project to the back of the courtroom as best you can.
Okay.
The microphone is for does not amplify your voice. It's for recording purposes. Ms. Wilson, you may proceed.
Thank you, Your Honor. Officer Backery, just to recap a little bit about what we had gone over. I believe you had previously testified that you were working as a police officer on April 11th of 2024. Is that correct?
Yes.
And that you had done a stop at 325 City Market Drive or Rotary Park.
It was a park check.
Park check, okay. And that you had made contact with some individuals there?
Yes.
And that in the back seat of one of the vehicle, or the back of one of the vehicles, you saw suspected narcotics in plain view, is that correct? Okay. Now I believe when we left off, we were talking about the weight of the narcotics. Did you have an opportunity to weigh them?
Yes.
And what was the weight?
The suspected crack cocaine was 12.5 grams. And the suspected methamphetamine is 14.5 grams with fact.
Okay. And do you have any experience in narcotics?
Just my experience dealing with it on road patrol.
Okay. Have you encountered any, or have you investigated any sort of narcotic sales before?
Yes.
And based on your knowledge and experience, is the weight of the narcotics that you found typical of
I'm gonna
a
object to the
use?
cause for speculation, Your Honor.
Response?
Thank you, Your Honor. It's based on the officer's knowledge and experience. I don't think it's speculation. This is something that he works on. I'm not asking him to say what these narcotics specifically were used for, but rather based on his knowledge and experience, typically if that's a regular amount for use.
All right. Response, Mr. Simmons.
I would again just reiterate my objection. This officer's not been qualified as an expert. This officer testified previously that he doesn't have any specialized training, that this would be pure conjecture and speculation on his end to differentiate between what would be quantity for personal use versus what would be quantity for sales. Thank you.
Based on the experience of the officer, I don't know if we went into this record. I don't see how many years he's been on the road.
I can ask that, Your Honor. How long have you been an officer?
Just over 5 years. years.
5 years. And during your time, have you been with LPD that entire time?
Yes,
And during your time with LPD, have you been strictly on road patrol or have you been on any special assignments?
road patrol.
Road patrol, okay.
Right, for purposes of preliminary examination, the officer can indicate that based on experience, mostly based on experience and 5-year record under 702, that this was the weight appeared to be for purposes of delivery, not for possession purposes.
Okay, and I guess we didn't get to the answer, so I will just restate the question. The amount of the narcotics that you found based on your experience, is that typical of a use amount?
No, it is not.
No, it's not. What is that typical of?
Someone who was selling that.
Okay, I have. I have nothing further than
All right, cross-examine Mr. Sartz, and I think did you have the opportunity to cross-examine last time?
He did not, no.
All right, so full cross-examination, Mr. Sartz.
Thank you, Your Honor. Just to briefly follow up. Did you conduct a search of the vehicle yourself?
I did not.
So
Besides the plain view search.
besides a plain view search. Okay. So you were relying on the information that other officers were providing you
In regards to,
in terms of some of your testimony here previously?
could you rephrase what testimony you're speaking of?
Sure. So when you said you were not involved in the search, that the extent of the search that you were engaged in was just a plain view search, correct? Okay. So by definition, all that means is that you first approached the vehicle and you observed what you observed, correct?
Yes.
Okay, so you were not directly involved in the actual search of the vehicle itself or the recovery of the narcotics themselves or anything else, correct?
Correct.
Okay. And in terms of the search of the vehicle, in terms of the plain view, did you observe any small individual baggies or anything else on the floorboards?
Inside the vehicle, no.
Okay. In terms of the kind of plain view, where do you recall what you allege was the suspected baggies? Where were they found again?
They were on the passenger side rear floorboard, right behind the passenger seat, the front passenger seat.
Front passenger seat? Okay, they're on the floorboard, you said?
Yep.
And were the windows tinted at all?
The back ones have factory tint on them.
Okay. And was there anything else near the floorboards or any other debris or any other objects?
I believe that there was. I don't know exactly what objects.
Okay. And approximately how many people could fit in the back of that particular make and model, to your knowledge?
In that particular back seat, just that portion of the back seat has 3 seats.
Okay, so it has a kind of like a back row with a seat in the middle.
So if you're talking about the third row, I don't recall if that was up or not, or even in the vehicle. As far as just the actual back seat where I saw the narcotics in plain view, that just fits 3.
Okay. And there were 2 other people in the vehicle, correct?
Yes.
Okay. And just to clarify, at the time, you did not do any true narc testing or anything along those lines.
No, our
correct?
true narc was down.
No further questions, Your Honor. Thank you.
Thank you. Ms. Wilson, any redirects?
No, Your Honor, thank you.
May this witness may Officer Macri be excused
You may, Your Honor, thank you.
from the defense.
Yes, Your Honor. Thank you.
You're excused, sir. Thank you for your appearance today.
Thank you, sir.
And the people may call their next witness.
Thank you, Your Honor. We'll call Officer Donovan Moore. Thank you.
Okay, Officer Moore. And right in front of me, and state and spell your first name and last name for the record.
Donovan Moore, DONOVAN MOORE.
Please raise your right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
All right, have a seat. Once again, the project as best you can for amplification purposes. And Ms. Wilson, you may proceed.
Thank you, Your Honor. Officer Moore, where are you currently employed?
The Lance Police Department,
And what is your job position?
a road patrol officer,
How long have you been a police officer?
5 years now.
Is that all at Lansing Police?
Yes,
Okay. Were you working as a Lansing police officer on April 11th of 2024?
yes,
And did you have occasion on that date to be at 325 City Market Drive?
yes,
And did you make contact with anybody at that location?
yes, I did.
Okay, so when you got there, what was happening?
So we remain in contact with the vehicle. It's park after dark because there's been a lot of gun crimes over there too, a lot of shootings. So we tend to check the park a lot. I arrive to that park and I see a black GMC SUV. Headlights were running, the car was running, headlights were on, car was running. I saw like phones that were moving inside. I jump out of my car, start walking towards the vehicle, and as soon as I do that, headlights shut off. I see the phones go away, and I see the car kind of go back and forth. I see everybody exit the vehicle, and at that point, I had a very clear view. I mean, there's lamps right there, so I could see everybody exit the vehicle.
And how many people got out?
3 people.
Okay, and where were they getting out of?
Tequila Armstrong got out of the driver's seat. Kenneth Wilson Jr. got out of the front passenger seat. And Emil Moore got out of the back seat on the passenger side.
Okay, and you said that it was well lit there?
Yes,
And you had a good view of everyone?
yes.
Your Honor, I'm just going to object on the grounds that you would know the person by the identifications at that particular moment.
I don't know if that's a legal objection.
I don't think it is.
So you can cross on that, but you can definitely cross on his experience with the individuals if he knows them.
Yeah, I suppose the objection would have been on lack of foundation as to how I would have established ID, Your Honor.
All right, so we're allowed to come out on cross if need be. The objection right now is overruled at this point in time, and you may proceed, Mr. Dixon.
So Officer Moore, the individual that you said was coming out of I believe you said it was the rear passenger side. Did you get a good look at that person?
Yes.
Do you see him here today?
Yes.
Can you point him out and describe something he's wearing?
To my left is wearing a plaid colored long sleeve that's rolled up and with the green t-shirt.
Your Honor, for the record, I just request that it reflect identification.
Identification for purposes of preliminary examination. Any objection, Mr. Starks?
To preserve the issue, yes, Your Honor, on lack of foundation.
Thank you. With that understanding and the understanding and objection, the witness has identified the defendant.
Thank you, Your Honor. So Officer Moore, at any point, did you speak with the individual that was coming out of the rear passenger side?
No, I didn't have a chance to originally. Everybody started exiting the vehicle. Kenneth Wilson, he immediately started coming towards me. I was still trying to keep an eye on the vehicle because Kenneth was coming towards me. Tequila was coming towards me, but Emil, I was paying attention to him because he stayed by the vehicle. I saw him get out of the vehicle. He dipped back towards the vehicle. I saw his arm stretch out towards the floorboard of the rear passenger, in the back seat of the rear passenger seat, and then come back out and close it up.
All right. And the vehicle was subsequently searched, is that correct?
Yes.
Did you participate in that search?
No, I did not.
Okay, I have nothing further, Your Honor.
Cross-examination, Mr. Starks.
Yeah, just briefly, how far were you away when you claimed that you saw Mr. Moore take some type of gesture into the vehicle?
8 feet.
About 8 feet. And this was, how was the visibility in the park at that point? This was very early in the morning, correct?
1:30 around, yes.
Okay, this was around 3. And at the time, you were about 8. Was there anything that would have obstructed your view of the vehicle at that point?
No, I was walking pretty fast towards the vehicle. As soon as the car started shutting off, I No, I was right there.
What were the lighting conditions like at that point?
It was lit. I mean, the lights are on all night. It's a city park and stuff, so they usually keep the lights on a lot at Rotary Park.
Did you see or observe a door being opened?
Yes,
Okay, and the door didn't block your view?
briefly, yes.
Okay, so the door blocked your view of what this person was allegedly doing, correct?
No, I did see him reach back and towards the vehicle. I did not see what was in his hands. That's what you're kind of asking me, but I did see his body go back and his hand go back in the vehicle.
Okay, you didn't see what was in his hands?
Correct.
Okay. And were there any other possible obstructions?
No.
And you're claiming that you're able to identify the person here, but what is the foundation for why you would?
Objection, that's a legal question.
Okay. What's the basis for your identity?
Identifying him?
Yeah.
It was in a park after dark. It's a city ordinance that we have.
Okay, but at the time, you didn't know the person's identification when you first approached the vehicle, correct?
Correct.
Okay. So how did you learn of the person's alleged identification later on?
Oh, later on, after he was arrested and taken to the jail, he told officers their name, and at the jail, he was also told the detention officers his name.
Okay, so at the time, you didn't know the person's identification?
Correct.
Okay. Sorry. And were you at the park before they arrived, or did you see the vehicle arrive?
I did not see the vehicle arrive, no.
Okay. So were you on patrol and then you just stumbled upon the vehicle? How did you initially arrive there?
I was in a two-man vehicle, fully marked patrol car in a full uniform. We tend to check that park every now and then whenever we get a chance. So we were initiating proactive work at that park.
Okay. What other officers with you at that time?
Officer Robertson.
Officer Robinson. Okay. Thank you, Your Honor. Nothing further.
Any redirect, Ms. Wilson?
No, Your Honor, thank you.
May this witness be excused from the people?
You may, Your Honor.
Mr. Sarves.
Yes, Your Honor.
All right, thank you, your officer, your subpoena. Further proofs today, Ms. Wilson.
Yes, Your Honor. Can you grab Robertson? Thank you. The people call Officer Alexis Robertson.
Officer Robertson, you can come up here. I want you to stand right in front of me and tell me, tell and spell your first and last name for the record.
Alexis Robertson, Alexis, last name Robertson, Robertson.
Please raise your right hand. You solemnly swear from tell the truth, full truth, and nothing but the truth under penalty of perjury.
I do.
All right, now go ahead and have a seat. The microphone is for recording purposes to the court recorder. So please project as best you can, all right, ma'am?
Yes, sir.
Ms. Wilson, you're ready.
Thank you, Your Honor. Officer Robertson, where are you employed?
City of Lansing Police Department.
And what is your title?
I am a road patrol canine officer.
And what are your general duties?
I respond to calls and take calls that are dispatched to us.
How long have you been a police officer?
Just over 7 years.
And has that been entirely with LPD?
Yes.
Okay. In your time with LPD, have you had any special assignments?
Yes.
What are those?
I am just a canine officer now.
Okay. Were you working as a Lansing police officer on April 11th of 2024?
Yes.
And on that date, did you have occasion to be at 325 City Market Drive?
Yes.
Okay. So I'd like to fast forward a bit in the series of events here. At some point, did you assist in a search of a vehicle there?
Yes.
And did you find anything in that vehicle?
Yes.
What did you find?
Officer Backery advised that he observed possible narcotics in the back.
Objection on the grounds that his comments would be hearsay.
In fact, on the list.
Right, okay, so I won't use it substantively, we'll just use it for effect on the listener, and then if the witness will testify to what she did herself
Yes.
and saw.
You may proceed. I believe you were saying Officer Backery told you something.
Yes, so he observed something in the back seat, so I got my canine partner Echo.
And what did you do after that?
I took my dog to the front of the car and gave him his command, and then he did his sniffing around the outside of the vehicle, and he alerted to the odor of narcotics on the vehicle.
Okay, and once you got that alert, what happened?
We searched the vehicle.
And did you find anything in the vehicle?
Yes.
What'd you find?
I found suspected narcotics in the rear passengers.
Okay, anything else?
After searching the vehicle, I found a scale.
Scale, and where was that located?
I believe the center console.
Okay. I have nothing further.
Cross-examination, Mr. Service.
Thank you, Your Honor. So what is Canine Echo's experience in terms of being a search canine?
We are narcotic detection certified. We've been with each other for approximately 3 years now.
Okay. How many searches has Canine Echo participated in?
I would say approximately 20 plus.
Okay, and it's safe to say that Echo has a very strong food drive, correct?
Yes.
In fact, he found pizza in the back seat of the car.
Yes.
Okay, and helped himself?
Yep.
Okay, so in your experience in training, isn't it possible that strong odors of food, for example, can interfere with the dog's training for narcotics?
I honestly don't know.
Okay, in your experience in training, isn't it true that dogs will do false alerts, for example, if they find something like food or something else that they're trained to potentially sniff out?
I do not know.
Okay, and by the point that Canine Echo was already brought in, there had already been a plain view observation by Officer Backery, correct?
Yes, sir.
And this was the way it was described, more of a training exercise for your canine, correct?
Yeah.
But your canine got in and needless to say, after alerting on outside, went in and found some pizza. And where was that pizza located?
Your Honor, what's the relevance here? I mean, we've already got that there was food in there, that the dog got into it. Where are we going with this?
Okay, where was the pizza located in relation to this?
I'll allow that answer.
Alleged narcotics.
I believe it was in the trunk. I'm not 100% sure.
Okay. And where do you call the canine alerting to?
He gave me indications around the vehicle and then on the passenger side.
Okay. And was there other foodstuffs in the vehicle?
I don't recall.
Okay. And you searched the vehicle?
Yes.
Did you observe any lottery tickets or small baggies or other items along those lines?
Not to my knowledge, no.
Okay. How about cutting agents? How about baking powder? Anything else along those lines?
I don't recall.
Okay. And in terms of the baggies themselves, there were only 2 baggies that were found, correct?
Yes.
These were individual sized baggies, correct?
Yes.
Okay, so these baggies weren't split off into smaller segments or smaller chunks or anything along those lines, correct?
No.
And you didn't find any log books, for example, detailing transactions. You didn't find any other printouts, maybe a bunch of random phone numbers, anything else, correct?
Not to my knowledge.
Not to your knowledge. And you said Officer Echo, your partner, the canine has participated in approximately 20 other searches. Were those all narcotics?
Yes.
Okay. Does canine Echo participate in any other types of searches for other substances?
Just narcotics.
Just narcotics. Okay. And you've been his handler for the entire time that he's been on the force?
Yes.
Okay. And in your experience with Canine Echoes, has there ever alerted falsely in other cases?
Not to my knowledge, no.
Thank you, Your Honor. Nothing further.
Any redirect, Ms. Wilson?
Briefly, Your Honor. So Mr. Starks had asked you about whether there was a plain view notice of suspected narcotics. Is that correct?
Yes,
And Officer Bakri had informed you that there were?
yes.
Okay. And so in your experience as a police officer and a canine officer, when you have suspected narcotics in the back of the car and a canine alerting in that location, what does that tell you?
That he indicated on the odor of narcotics.
Okay, nothing further, Your Honor.
May this witness be excused, Ms. Wilson?
May, Your Honor.
Mr. Sarks?
Yes, Your Honor. Thank you.
You're excused, witness. Thank you for your appearance. Further proofs today, Ms. Wilson?
Yes, Your Honor. The people will call Officer Watkins.
Officer Watkins, I'll have you approach. And you can stand right in front of me and spell and indicate your first name and last name for the record.
First name is Andrew, Andrew. Last name is Watkins, Watkkeys.
Please raise your right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
Right, have a seat. Project to the back as best you can. As you know, the recording, the microphone is for the court recorder. Ms. Wilson, you may proceed.
Thank you, Your Honor. Officer Watkins, where are you currently employed?
Lansing Police Department, City of Lansing.
And what is your job title?
I am the regulatory officer.
And what is that?
It is the officer within the special operations section that handles regulatory licensing as well as aiding the special operations section.
Okay, and how long have you been an officer?
8 years here in July.
Okay, and has that entire time been with LPD?
Yes.
Okay. So prior to your current position, did you have any training in narcotic testing?
Yes.
What kind of training did you have?
I have training with field testing, so testing on the field, and then I also have training with the TrueNarc analyzer.
Okay. Now on June 26th of 2024, did you have occasion to TrueNarc some narcotics?
Yes.
And can you tell me a little bit about where those were located?
They were located at the LPD headquarters property and supply unit in the back office where all evidence is located after it's tagged.
Okay, and once it gets into that location, is there some kind of record of who has access to that?
Yes.
And in this specific instance, did you pull those records?
I did.
And did you see any anomalies in who had access to those particular narcotics?
I did not.
Okay. And so you said you had tested those, correct?
Yes.
And what were the results of those tests?
The result of item 1 when I tested it was a cocaine base using the TrueNarc analyzer. The result of item 2 was methamphetamine, and the result of item 3 was acetaminophen. Specifically stated that the presence of narcotics could not be ruled out.
Okay, and when you went through the testing procedure, did you use the procedure you have been trained to use?
Yes.
Okay. Now I want to talk about item 1 a little bit, about how large was that sample?
Golf ball size?
Golf ball
I
size?
had to pick a size.
Okay, and was that the entirety of the amount that was in evidence?
For item number 1,
Yeah,
yes.
okay. Okay, I have nothing further.
All right, cross-examination, Mr. Sarnes.
Just briefly, approximately how much quantity did you observe in terms of item number 2 that you tested?
I did not weigh item number 2.
Okay.
But it was about a golf ball size as well.
Okay, it was about a golf ball size?
Yeah, approximately.
Okay. And to your knowledge, had those particular items been taken out of the evidence locker at any point previously?
Not that I'm aware
of. Okay. Approximately how long have you been employed on the force?
Here at the police department, 8 years. in
8 years.
July.
Okay, and approximately how many true narc tests have you performed in the course of your career?
I would say 100.
Do you have any specialized training in terms of this type of testing?
Yes, I work with the special operations section where I
Okay,
try not to test drugs frequently.
but you don't have any additional separate training or anything along those lines?
I'm not understanding your question.
Sure, like, do you take any additional courses on how to utilize the TrueNarc testing proceedings? Have you ever had any separate follow-up training other than just?
Understood, no.
No, okay. And do you have gloves when you're doing the testing?
Yes.
And is there some type of written protocol or some type of manual in terms of how you're supposed to perform these tests?
Yes.
Okay, and when was the last time you reviewed those materials?
Last year.
Last year?
Yeah, I actually trained the department on the use of materials through the manual.
Okay. And to your knowledge, were those particular baggies, were they ever tested for prints? Were they ever further tested beyond just the TrueNarc test?
Not to my knowledge.
Okay. Has a sample been sent off to Michigan State Police, to your knowledge?
No.
Okay. And you referenced the third quantity as something that you tested. Approximately how much of a quantity of an item was that?
Teaspoon? It was inside a dollar bill, so it wasn't a lot.
Okay, so very, very, very small quantity. Safe to say? Teaspoon?
Teaspoon?
Yeah. Okay, thank you. Nothing further.
Any redirect, Ms. Wilson?
No, Your Honor, thank you.
May this witness be excused from the people?
You may, Your Honor, thank you.
Mr. Sarts, may the witness be excused?
Yes, Your Honor. Thank you.
Right, thank you, Mr. Watkins. You're
Thank you.
excused from your subpoena. Any further proofs or witnesses, Ms. Wilson?
No, Your Honor, the people rest.
Any proofs today, Mr. Sarts?
No, Your Honor, thank you.
Motion for bind over, Ms. Wilson.
Thank you, Your Honor. The defendant in this matter is currently charged with two felony counts. Count one being delivery and manufacturing of methamphetamine, specifically under the theory of possessing with intent to deliver. And count two with being delivering and manufacturing cocaine less than 50 grams, specifically under the theory of possession with intent to deliver. You heard here from multiple officers today and at the previous exam that they had made a stop at 325 City Market Drive. It's in the city of Lansing, Ingham County, state of Michigan. That was on April 11th of 2024. So to a probable cause standard, I believe the elements of venue and date have been met. You heard from Officer Moore that an individual he identified as Emil Moore had come out of the back seat and was subsequently arrested. And he later learned of Mr. Moore's identification when Mr. Moore provided his name at LPD lockup. So I believe the element of identification has been met. As to the elements of the offense here, we do have a large quantity of methamphetamine found in the rear passenger seat floorboard of the vehicle, in which Officer Moore stated that Mr. Moore had gotten out of, and not only gotten out of, but made some kind of movement adjusting something within the vehicle. We also have a decent amount of cocaine located in that same location where the defendant again was exiting and making movements towards. Officer Backery testified that based on his experience as an officer, the amounts that he found were not typical for a use. In addition, Officer Robertson testified that she found scales in the center console. So I believe that there is some circumstantial evidence here that between the amount and the scales, that there was an intent to deliver these items. So I would be requesting bind over as charged.
Thank you. Mr. Sart's response.
Thank you, Your Honor. I respectfully, the defense would object to the proposed bind over and request that these charges be dismissed. The people have the burden of showing that not only was the accused individual possessing the items, but also that there was some type of intent to deliver the controlled substances or manufacture the proposed substances the alleged substances for those purposes. And quite frankly, the circumstantial evidence that was testified to here and requested as the basis for the potential bind over here is very weak in terms of the probative value versus the nature of the allegations here. Respectfully, a single scale is not reflective of an intention on the party to deliver or participate in the sale of narcotics. There was no testimony here about alleged cutting agents. There's no testimony here that this particular quantity had been divided in any way, shape, or form for the purposes of sale. There's no testimony here about any cutting agents. There's no testimony about any alleged transaction logs, phone records, anything else that would go to suggest that there's some type of intention to either participate or manufacture these substances for the purposes of delivery. Now, certainly there's circumstantial evidence of possession, but even then there's certainly questions about possession in terms of who these alleged items belong to. Granted, it's circumstantial with perhaps Mr. Moore being identified as a person being in the back seat, but there were two other occupants of the vehicle at that time who obviously would have had access to that particular location based on the officer's testimony, based on the officer's descriptions. This was a type of vehicle where Officer Backery noted that potentially you could even have a third row. So multiple people at a minimum had access to that particular location. And saying it is circumstantial, but respectfully, it's not strong enough circumstantial evidence to bind over Mr. Moore on the allegations that he was engaged in these types of alleged activities. Respectfully, Your Honor, I would request that the case both counts be dismissed.
Thank you. Response, Ms. Wilson.
Thank you, Your Honor. As to the possession, it is constructive possession here. It's not found on his person, but it is in the back seat where he was. He is the last one to come out of the car, the last one that had the opportunity to move items in the car. So I think there is strong evidence here of constructive possession. Additionally, as far as the intent to deliver, there is case law out here, and I can't remember the case off the top of my head, where weight alone is sufficient evidence for an intent to deliver. And here we have weight and a scale. And I recognize it was only one scale, but nevertheless, it was a scale. I don't think it takes an expert to put two and two together. When you have a large amount of narcotics and a scale, there's something going on there. Most people who are using don't do that. So I think there is sufficient evidence to a probable cause standard here today as to both counts, and I would renew my request for bind over.
Thank you. The level for preliminary examination is probable cause being the second lowest standard in criminal law, reasonable suspicion being a lower standard. I find that based on the testimony of Officer James Backery, Officer Donovan Moore, Officer Alexis Robertson, and Officer Andrew Watkins, that the date has been made as to April 11th, 2024. The venue and location have been made as to 325 City Market Drive, City of Lansing, Ingham County. And the defendant was identified, I believe, by at least two of the witnesses. Officer Backery and Officer Moore both identified the defendant. So as to the elements of the crime, it is bound over in count one. I do find probable cause to believe that the defendant was in possession with intent to deliver the controlled substance of methamphetamine under count one. I think if I remember correctly, that was described as item 2 that was tested, and it was referred to as a golf ball size piece of evidence. There was indication that the defendant, that this is constructive possession pursuant to Maryland v. Pringle and other case law, that this was was constructively possessed in the back seat of the car. Mr. Moore also is identified as by Donovan Moore, Officer Moore, as a person who saw him go into the back seat and come out at a distance of maybe 8 to 10 feet proximity wise. Officer Backery also testified that this was located at the and in plain view in the back of the car. And then Officer Robertson testified that the canine was used in addition to finding drugs and other implementation there, or other sources of what they hit upon there. So I find at probable cause level, the count one is met. As to the methamphetamine found in the car, tested positive for tested by Officer Andrew Watkins, positive for methamphetamine, and therefore probable cause to believe the count one is bound over as charged as to location, fence, venue, ID, and date. And count two, for the same reasons, the mixture of cocaine that was tested by Officer Watkins using TrueNarc found the presence of cocaine. That baggie was found next to the methamphetamine in a similar location. Mr. Moore was the last one in the back seat of the car, and then was able to be seen going in, which Officer Moore was absolutely candid when indicating he did not say what was in the hand, that he was somewhat partially blocked by the door. But this is once again constructive possession, and therefore the court finds that a probable cause to believe that the defendant did possess with intent to deliver less than 50 grams a mixture containing the controlled substance of cocaine, and it binds over on count 1 and 2 as charged, based on the testimony of the 4 witnesses. And I have the bind over documentation.
Just to confirm, Your Honor, the habitual offenders fall on as well?
Yes, there's an habitual offender 4th offense notice that will follow to circuit court. So yeah, that will follow this to circuit court. And the examination was held on today's date, June 26, 2024, and is bound over as charged on both counts, and the habitual offender will follow. Anything else for the record before I sign the bind over documentation on docket 24-01094, Ms. Wilson?
Not for the people.
Mr. Sarvis.
No, Your Honor, thank you.
All right.
I will request a copy of the transcripts.
All right, and I have, we'll entertain that the request has been made for the copy of the transcripts. Mr. Moore, your time in district court done on this file is now done, and you'll get your next date in circuit court from your attorney, Mr. Sartz. All right, sir? All right, that's all for the record in 24-01094. And then we should probably arraign him on the current file. And Mr. Sartz, you're here for representation purposes on this file, is that correct?
Yes, Your Honor, I'll stand in and handle it.
So we're on the record in docket. This is 24-01726. And once again, sir, you are Emil Moore, is that correct? Thank you. Counsel, your appearance for the record.
Abigail Wilson to the people.
And Mr. Sartz.
Good afternoon, Your Honor. Jacob Sartz, support the Assistant Public Defender here on behalf of Mr. Moore for his arraignment.
All right, this is the time set for arraignment, so I'll read you the new charges that have been alleged against you by the people of the state of Michigan. It is alleged that on or about January 24th, 2024, at the offense location of Sunset Avenue and Kaplan Street, City of Lansing, Ingham County, that yourself, Emil Moore, did in count 1 possess with intent to deliver the controlled substance of methamphetamine, contrary to MCL 333.7401 TBI, T parents B parents I, that is a felony, 20 years and or $20,000. The court shall order law enforcement to collect a DNA identification profiling sample before sentencing or disposition if not taken upon arrest. Mr. Moore, do you understand the nature of the allegations that have been brought against you? All right. You have certain rights in this matter, and I'm going to read you your felony rights in this matter. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that appear against you, to have any court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If the please accepted, so to testify at trial, if you choose to testify, do you understand your jury trial rights in this matter, sir? All right. You are set for, we set it for pretrial. Okay.
Probable cause is July 5th at 8:30 in front of you.
So set for probable cause conference on July
5th at 8:30.
at 8:30 in front of myself.
And the following prelim, July 11th at 8:30 also.
Okay, and the prelim will be set for July 11th at 8:30. That's also set in front of myself. So they're both at 8:30. Okay. You are represented today by Attorney Jacob Sartz from the Public Defender's Office. Do you plan to seek additional representation from the Public Defender's Office on this file?
Yes.
Okay. I'll indicate a yes for purposes of the Register of Actions. Are you still at the same address and phone number? Can I just indicate on Roselawn, and that's still, you're still a good phone number there? Okay. And phone. Sir, are you on probation or parole right now? Are you employed right now? Say it again, man.
I should know I'm about to go for an interview next week.
I'll enter a not guilty plea for purposes of this arraignment. Mr. Sartz, would you like to be heard on bond?
Thank you, Your Honor. It's my understanding that the allegations here predate allegations that Mr. Moore is currently on bond for. To Mr. Moore's credit, and Your Honor's aware, he's showing up for his court dates. There's been no allegations, any bond violations to my knowledge when he's been out on bond. Before Your Honor, respectfully, he does have a very complicated situation where he's taking care of his daughter. His daughter has very serious medical issues. She requires a lot of care. Mr. Moore has very stable roots in the community. He's not a flight risk at all. His mother lives in the area. He also has friends and family who can help keep track of his location. And Mr. Moore, to his credit, has appeared before Your Honor on multiple occasions. So respectfully, based on his proven track history, based on the fact that he's not a flight risk, based on his deep connections to the community, I would respectfully request a personal recognizance bond. Mr. Moore is indigent. He's not able to reasonably afford a significant cash bond. And given the amount of supervision he'll be under, which will be quite extensive, I would respectfully request a personal recognizance bond.
Thank you. Ms. Wilson, would you like to be heard on bond? I think bond on the other file was set at 10,000, 10%.
It was, Your Honor, and I think something similar in this matter would be appropriate. Mr. Moore does have an extensive history with these types of offenses. He's now looking at 3 counts of possession with intent to deliver. These are high severity felonies. There's a long history here. There's a lot of impetus here to flee, to not participate. I understand that he has participated thus far, but as the pressure grows here, I'm sure the court's aware that sometimes things fall off. So I think that a similar bond in this matter would be appropriate. And then the typical terms and conditions upon release: no controlled substance, no firearm, such the like. Yeah.
Thank you. So I've had the opportunity to review the criminal history in this case. And I'll indicate for the record, there's dating back to 2000, there's felony behavior, narcotics behavior in 2000, 2005. There's some traffic stuff. There's looks like the drug activity out of 2008. Retail fraud out of 2017, and then some misdemeanor stuff, and then looks like 2019 narcotics, felony narcotics, and then was just found over on felony narcotics, which is only bound over on a probable cause level. So I will indicate for the record that the the defendant have no alcohol or drugs without a prescription. If you're able to make bond and bond is set, no assaultive behavior, no out-of-state travel, no possession of a firearm, and to report to pretrial services within 48 hours. I'm going to set the bond accordingly at 10,000, 10%, which was the same as the other case with similar charges. Anything else for the record in 24-01726, Ms. Wilson?
Top of the people.
Mr. Sarts.
Nothing further, Your Honor.
All right, thank you. So I've set bond at 10,000, 10% today.
Thank you, Your Honor.
Thank you, Mr. Soros. Oh, coverage on your other file worked out okay.
Yeah. Thank you.
All right, you're all set.
Wendy's canceled court tomorrow, just so you know.
She's not allowed. She has power, but she doesn't have that kind of power.
I thought I'd give it a shot, Judge.
Yeah, I know.